Proximal lordship, notice will go lordship.
ADN notice to respondent number 2. Blind.
May please, your lordship. Starseated case pilot, intermediate quantity 8.2 kg of ganja has been recovered as per allegation. But seizure witness, my lord, they stated that this is not a ganja, this is a leaves of bhang.
To examine.
Proceed.
Can copy of TCR.
102 days intermediate quantity.
10 more days. Is difference between bhang?
Proceed.
Bhang is not an offense.
But it was not, my lord, it was not listed in the NDPSA.
Any other name?
ভাঙরের নাম গাঞ্জা নহয় জানো সেইটোৱে ভাঙটোৱেতো স্যাৰ ৰঞ্জন দা
Lordship, here I am only paying for case diary. $27.
May I please, your lordship? Let's call for a case diary. Allegation against the petitioner is with several sections of which something prohibition. Oblige.
কিমান ডেটটো নালাগে নেকি আৰু ক'ত দিয়ক অঁ 28
May please, your lordship. Lordship, here, lordship, it is intermediate quantities. The petitioner is in the custody since last 53 days, lordship. And recovery is, lordship, 12.23 grams of suspected heroin, lordship. Page number 20 is the FIR.
Right, CD.
It is 53 days, lordship.
I have filed charge sheet also, we don't know.
that one I'll have to take a
Any date, lordship, before 60 days.
let it be on Tuesday
Yes.
18
Same prayer in respect of item number 9 also.
Right, CD stroke TCS. Okay. Scan copy of TCR. Because it may, if it is charge sheeted,
If
then
that-
that will.
Cash sheeted.
Hmm.
Hello.
same বলে 18 এর
May please, your lordship. Lordship, kindly the matter may be taken after some time. Take this question. Lordship, case diary may be called for, madam.
CD.
19. 25. 26. 26. 26. Deep. ma'am.
Please, your lordship. Pre-arrest bail application, lordship. Lordship will find the FIR on page 14, lordship. I read. With due respect, I have the honor to report that on 19/7/26 at about 1:26 PM, information was received that a Mahindra Thar bearing registration number so-and-so had overturned on NH 37 near Punjan Ali under the jurisdiction of Siksagar Police Station. On receipt of the information, I, along with my staff, immediately proceeded to the place of occurrence. On reaching the spot, it was found that the said Mahindra, while proceeding from Pragati Sariali side had hit the road divider and overturned. The vehicle was searched in the presence of witness, and during search, 15 cases of Tuborg beer containing 360 can marked for sale in Assam only were recovered from inside the vehicle. The said Mahindra vehicle Thar was thereafter towed to the police station. The recovered beer was seized as per law and deposited to the police station Malkhana. However, neither the driver nor the owner of the vehicle was found at the place of occurrence. As per the statement of local people, the driver fled from the spot immediately after the accident. Subsequently, during the course of inquiry, it came to light that the accident Mahindra Thar bearing registration number was being driven by Dhrubajyoti Gogoi and address so and so. It was further ascertained that Sri Rishikesh Bora, address so and so, was traveling in front passenger seat of the said vehicle. The seized consignment of beer was being transported to Jorhat under the supervision of Rishikesh Bora. During inquiry, neither the driver nor the passenger could produce any document establish the ownership of lawful possession of the seized vehicle. They also failed to produce any valid purchase invoice, sale voucher, transport permit, excise pass, or any other documentary evidence to establish the lawful possession of transportation of seized beer. In view of the above facts and circumstances, there are reasonable ground to suspect.
Who are you? Rishikesh Bora,
Rishikesh Bora is the owner, Lordship, and I have the
owner of the vehicle or the consignment?
consignment also, Lordship, they have purchased, and I have annexed the receipts, and ownership has been transferred by one Rajiv Kasar, and whose original sales certificate is at page 26, Lordship. He was the original purchaser of the vehicle. Then he handed the vehicle to one Nagaland Motors, who deals with second-hand cars. And then from Nagaland Motor, the petitioner number 2, Rishikesh, purchased the said vehicle, Lordship. And there is a
Is this
agreement.
about the vehicle or the beer?
Here is also, Lordship, they have
What
actually,
is the
Lordship,
section?
actually, Lordship, what happened after the vehicle met an accident, because there was a cow who was which was passing the road, and they got into a divider, and the uh, car has overturned in the road, Lordship. And after that, the driver got a minor injury. He went to look for a pharmacy, and the owner, Rishikesh Bora, he went for looking at towing vehicle. Then the police came and they towed it. Now the Rishikesh Bora has earlier approached the police to hand over the vehicle, but they were asking money that they have towed the vehicle, they have to pay. And there is a reasonable apprehension that Lordship, if they do not pay, the Lordship, the police are before the petitioners, Lordship. Because of the
So
towing.
what are the sections now?
Sections is theft in dwelling house, criminal breach of trust, public nuisance, and Lordship, MV Act, rust and negligence, Lordship, and Excise Act, Lordship. Excise Act, Lordship, the section is
Only, my lord, why, international, my lord, they could not produce any documents, my lord. Now they have produced all the documents, my lord. There is a case memo, lordship may see the quality of the case memo, my lord. Annexure 3, my lord. Page number 17, 18 onwards, my lord. All the case memos are in the different person's name, my lord. Dhrubajyoti Gogoi, then Robin, Babu.
There is no
yeah.
complaint from anybody. Is it there?
There's no complaint for anybody. There's suo moto case, Lordship. Only thing is that they have towed the vehicle. They are asking for some money.
We'll examine the case there.
Interim may be given, Lordship. This Rishikesh Bora is a student, Lordship. And he has purchased the vehicle from one Rajiv Kasar, that is on page 24. And Nagaland Motors has handed over the vehicle on page 25, Lordship.
Counsel for the petitioner. The contents of the FIR. Vehicle met with an accident and certain quantity of 360 cans. 360 cans of beer. 15 cases were recovered from the said vehicle. Para learned counsel. Vehicle was being. The aforesaid beer were purchased. Were being transported in the said vehicle when it met with an accident. there was no illegality involved. On an additional PP that the CD may be called for. Call for the CD. The event of the arrest. Bail of rupees 20,000. To securities. Petition has to appear before the IO within a period of 10 days.
Deeply obliged, Lordship.
Your lordship. It's a 482 application, my lordship, and operative part of the FIR is at page 12, my lordship.
Hmm?
Page 12, my lordship, is the FIR, my lordship. Petitioner before your lordship is the notary, she notarized the affidavit, my lordship, on page 12, my lordship.
Who are you, notary?
Notary, my lordship. I will appear before the police, my lordship. Paragraph 3 of my petition, I have stated, my lordship, for 12/6/2026.
That is what happens when you don't insist on the appearance of the deponent.
I will go and appear before the, I will.
Notarize the affidavit for 100 rupees. What is the rate now?
40 rupees, 40. She was paid, my
30.
lordship. 30 rupees.
For affidavit is 30, my lord. For agreement is 100 rupees.
Yes. And in case of non-appearance, what is the rate?
Lordship, for 5 affidavits, she was paid 200 by the advocate, my lordship. GPay. Advocate identified and brought the affidavits, my lord. Buyer was also there on this.
Yes, Mr. Borua, your colleagues.
Only, my lord, only, my lord, her role will be clear from the case diary, my lord. Whether, my lord, the conspiracy part is there or not, my lord. Forgery part, my lord, he may not be directly involved, my lord, regarding the forgery part, my lord.
I will appear
Because-
before
because
the.
All probability, she signed it on the
Yes, he has only, my lord,
good faith.
verified the notary, but the case diary will reveal, ma'am.
Protected in interim, my lord.
Petition and learned. Application under so and
Because the offense is very severe. Even, my lord, these types of offense are earlier also occurred, this type of offense, my lord. One notary public also, my lord, I do not know whether she was arrested or not, my lord.
in the instant case, the circle officer, Rangya Revenue Circle, had lodged an FIR, where from it appears that certain affidavits, certain notarized affidavits were submitted support of the NOC applications for land sale permission. Which were submitted by certain persons, and upon verification, it was found that the deponents of the said affidavits never signed the affidavits. The petitioner herein is one of the notaries who had notarized the aforesaid affidavit. Call for the CD. On behalf of the petitioner that petitioner had bona fide signed the notarized the affidavit on the deponent being identified by the advocate. Directed that in the event of her arrest, the petitioner is on bail of rupees security of like amount. Here before the IO within a period of 10 days from today. Again.
application. So another bail application arising out of same case, my lord, was fixed on 19, my lord, being
Yes.
AB number 1676.
That is, okay, there is already called for, my lord.
It's the matter along with AB number
1676.
6119.
One number better, please.
1676. Relax.
May I please your lordship, allegation under section 318 subsection 4. My lordship, kindly turn over the page 14 FIR. May I read? সম্মানপূর্বক বিনীত নিবেদন নিম্ন স্বাক্ষরকারীর আবেদন এই যে যোৱা 24/2/2025 ইংৰাজী তাৰিখে এজন বন্ধ বেজ আমাৰ ঘৰলৈ প্ৰথম আহে দেউতাৰ লগত চিনাকি থকা বুলি কোৱাত আমি তেখেতক সন্মান কৰোঁ যিহেতু দেউতা ঢুকাইছে তাৰ পিছত তেওঁ পৰিয়ালৰ বিষয়ে নানা কথা আলোচনা কৰে প্ৰথম তেখেতে তান্ত্ৰিক কথা কৈ তাবিজৰ নামত 25,500 টকা আৰু দ্বিতীয়বাৰত পূজাৰ বাবদ 3500 টকা লৈ যায় তাৰপিছত তেখেতে এটা
Let us have the CD.
My lordship, petitioner
In
is
this case also, my lord, CD might have been called, my lord, in this case also, my lord.
Solve.
But the petitioner name is not reflected in this case.
Huh?
Petitioner name is not reflected in this case in the LA's FIR.
Where is
And petitioner name is not reflected in the FIR, my lordship. And petitioner is a
Very weird.
dialysis patient, my lordship, and undergoing treatment. One kidney already damaged, my lordship. In the meantime, my lordship.
Why are you here
police
then?
issued a
You have received notice.
notice only. So in the meantime, police harassed the petitioner. My lordship, situation is very dangerous. All kidney already damaged and undergoing treatment. He is hospital now. The annexer C, my lordship, is medical. Is number 19. His name is, he is a daily wage labor. He is not a tantric, my lordship.
They must have identified you from the mobile number.
Mobile number, I don't know.
No,
Let the
mobile number
case
is.
diary be called for, my lord.
Huh?
Let the case diary be called for.
In the FIR, they have given your mobile number, I think.
No. I am totally unknown about the fact, my lordship.
Your mobile number has been given in the FIR 8011598004. From that itself.
This
Otherwise,
number is only tantric, my lordship. Tantric. This is not my own. Situation is created only.
what is the name of the tantric?
I don't know.
You may be the tantric.
No.
Don't know.
I am not a tantric.
It is fixed on what date?
my lord.
CD is fixed in another case.
I have, my lord, so far I remember, my lord, similar, my lord, arising up to the same FIR, my lord, case has been, my lord, moved, my lord. I'm just trying to search, my lord, when does FIR.
Well, it will take up after some time.
No, this case is already withdrawn. Withdrawn.
Withdrawn,
But this is withdrawn, my lord, he has filed it.
right?
Maybe call for, my lord. No.
For the CD. Short date, we'll see.
Short date, my lord, 24, my lord, 24 August.
Yes.
Matter of option. This matter, your lordship, yesterday, your lordship disposed one about the son of the present petitioner who was arrested. And your lordship was pleased to grant bail yesterday, my lord, BA number 2275. Now kindly see the FIR, my lord, that lady, she is a major one. And about the allegation against the parents, my lord, nothing, only they demanded dowry, my lord, that part. Your lordship page, FIR is page, my lord, 11, your lord. No. What page? Start from page 13, main portion is my lord. Page 17, your lordship. 16 starts. So there was marriage agreement along with the accused number 1. That's it is.
There is yesterday's order is there.
Yesterday, just but it was not uploaded. I have been told. Yesterday, item number 4, my lord. BA number, that was BA number 2275. That is about accused number 1 who was arrested.
Gauhati Ray.
That was a regular bail, my lord. 2275. No. At motion stage, your lordship granted bail, man. Yesterday.
That was regular bill, maybe length of detention.
Regular bail. But here is a case, man, from the FIR, was kind of no allegation against this person, father and mother, man. Your lordship will find.
Order to আপনার double 275 কালি order হয়েছে এটালৈ একেলগে দি দিব we will see.
Obliged.
Against, my lord, all of the present petitioner is, my lord, he instigated the main accused, my lord, to assault him, my lord.
No,
And-
that is yesterday. Number
Yeah.
1 is the main accused, man.
Yes, he instigated the main
was
accused to
arrested, my lord.
assault her, my lord. And regarding, my lord, also, they also demand dowry, my lord. That part is there, my lord, from there.
Father and mother, man. And obliged to.
After some time.
Kindly matter may be taken after some time.
Hmm?
After some time, Lord.
My
Where
lord,
where is it come up?
otherwise, my lord will find a IA in the particular. I'll just, that is IA number. My lord, that IA, my lord has got it, my lord. One IA, yes. At page number, my lord, 11.
Subsequently, charge sheet was filed. That is why you got I.
My lord, event was 16/12/2025. Stay was granted by this honorable court. 16/12. And my lord, the charge sheet reveals, my lord, annexure 4 at page 11. Although it was filed on 18/10, but it was seen by the court only, the trial court on 19/1/2026.
What are we supposed to consider today?
But my lord, now only thing is this, since we have subsequently come to know about the charge sheet and the proceedings thereof and the taking of cognizance, I pray that, my lord, this IOM may be kept in abeyance along with this particular connected criminal petition, because here we have assailed the charge sheet as well as the order taking cognizance. So this may be, my lord, taken up along with the this particular criminal petition for final disposal, my lord, along with the criminal petition, my lord.
You want this to be posted for hearing. That is it.
Yes,
isn't
yes,
it?
yes, my lord. And record, my lord, record may be necessary for that.
Any difficulty with that? Third learned counsel for and number 2.
Yes, my lord.
The petitioner submits that the or maybe getting along with the connected IA number.
IL 760 up to 2026.
Can copy is already received.
Then it may be posted for hearing, my lord.
Hearing. On.
Deeply obliged, my lord.
Please, Lordship, I am for item number 17. And the leading advocate N. Hassan is not well today, so can it be fixed after 1 week?
When?
After 1 week, any date as per court conduct.
After 1 week. 17, 18. CD is here.
18, yes, but updated TCR is available, my lord.
My lord, I am for 17 and he's for 18.
When do you want?
Let it come together.
Huh?
Let it come together if she is having problem.
Sir, give a date.
20 August.
Yes.
My lord, can it be on 19, man? Always.
Alright.
Regular bail application, my lord, and charge sheeted matter, my lord. We are behind the bar for last 332 days, my lord, almost 11 months. And out of 9 witnesses, my lord, 4 have been examined, my lord, including the victim, informant, and her mother. Parrot page number 10, my lord. Medical report is not corroborated, my lord. The version of the victim.
Yes.
Page 94 is the medical examination report, man. Contrary, there is no, at page number 94, my lord. The conclusion of the medical report is at page number 96, man. Was found, my lord. Apart from that, my lord, the version of the victim, my lord, she has said that soon after the incident, she went to a house, nearby house, and she has named that person also, my lord, that she took help of that person, my lord, in calling to her family members, my lord. But the IO has not examined such person, my lord. That person is also not listed in the name of witness, my lord, by the IO. Apart from merit, my lord, or there is no threat now to the victim and or her family members, as they have already been examined, my lord. Inducement or any threat, my lord. Already almost 7 months behind the one. Yet, 5 listed witnesses are yet to examine. So, time may take, my lord, to conduct trial, my lord.
Yes, PP.
4 PWs have already been examined, and there is no delay, Lordship. And Lordship has seen evidence of the victim. He has clearly implicated, Lordship.
Supported by the immediate person who has reported, Bulumani Begum. She has repeated that version.
The offense is gang rape, Lordship, so
Huh?
it has to be seen, Lordship.
Yes, he is.
It's
I
Lordship.
was looking at the veracity. She
Yes.
said she immediately phoned her.
Yes,
She also confirmed that.
yes.
So there is corroboration also.
Make out a bail at this stage, Lordship, at least he has to show some ground on the merits as well as if there is some delay in the part of the prosecution in examining the witness. So far, Lordship, there is no such delay and trial is progressing, Lordship. Gravity of offense, Lordship. Yes, Lordship.
The informant is the grandmother of the victim. And the incident took place on, my lord, alleged incident on 13/9. And there is also delay in lodging the FIR, my lord. And at the initial stage, my lord, the victim refused for medical examination. Thereafter, she was examined by.
Amicus is also here, Lordship.
Yes.
Incident is of 13th. FIR was lodged on 14th. So they. Okay. Regarding the issue of medical, my lord, if your lordship sees the medical was done on 15th. Incident is of 13. So after 2 days, there is may not be there also, my lord. Right? Otherwise, the evidence is incriminating, my lord. Thorough appreciation of the evidence at this stage may also, my lord.
Plenty of corroboration is there. And there is no delay. It started in this year only. So under the section 35, 1 year time is there for completion of the trial. I heard learned counsel for the additional also heard Mr. Nawaz learned amicus representing respondent number decision application under so and so. The allegation against the petitioner is commission of penetrative sexual assault upon the minor victim aged about 16 years. The case, the trial of the case is now on course and already. How many? Four. Four witnesses, including the victim and the informant, have been examined. Learned counsel for the petitioner submits that the FIR was lodged belatedly and the medical report also does not support the version of the victim. Furthermore, there are number of witnesses yet to be examined. Submitted that the petitioner released on bail, as he has already spent how many
332 days.
days in bail.
4/64.
Para learned additional PP, learned amicus submits that the FIR was lodged immediately on the next day of the incident and hence there is no delay. And furthermore, since the victim was examined 2 days after the alleged incident, the medical report may not reveal any evidence of sexual assault. But the version victim has clearly implicated the petitioner. The same is also quoted by the person of the other witnesses. already deposed before the result of the record. I find forced the submission of it is also seen that the calendar of the case has been fixed by the learned trial court, and hence there is no possibility of indefinite delay. Furthermore, regard to the heinous nature of the offense, grant of bail at this stage. Accordingly, the prayer for bail stands rejected. All right.
Charges has been framed on 20 of June, Lordship. The victim has not yet been examined, Lordship.
With my lord, and will come after the victim has examined. Section 4 POCSO and 64 of the BNS.
Charge was framed on
Learned counsel for the learned additional PP has submitted that the charge sheet has been submitted. Charges are yet to be, have been already been framed, but the victim is yet to be examined. The petitioner submits that the pit closed as the
Liberty to approach after the
liberty to approach subsequent date. The petition stands closed with liberty.
deeply oblivious.
Lordship, service is complete. This may be appointed.
Amicus may be appointed.
Learned additional PP submits that service on respondent number is complete, but none appears. Accordingly, is appointed as MI served upon. Here has already been received the matter. Next week. Okay. Any amicus present? Keeper also.
May I please the lordship. Accused petitioner arrested on 15/11/2025 lordship. Two witnesses are examined by the learned trial court. Those are mother of the victim along with victim girl lordship. Both witnesses are declared hostile witness lordship. This honorable court has been granted bail to the co-accused petitioner lordship.
Is the order?
Lordship, kindly see, this is the order lordship.
Who are you? Co-accused means your name is Tamang.
Yes, lordship. I'm
Ranju Tamang has been granted bail already.
Ram Gyan Barik lordship, alias Mukun Barik lordship.
I suppose we have to pass the same order.
My lord, the victim, my lord, she was examined as PW2, my lord.
Yes, we have seen her. She
Page my
has
lord, page number.
all kinds of statements in her testimony. And she says he is, another
my
time
lord.
she says something else. Full of contradictions, her own statement. It will have same order.
Permission may be recorded, my lord.
Here already. Any days?
How many?
Lordship 25/11/2025, 15/11 Lordship 25 Lordship. Arrested on accused prisoner Lordship.
My question was different.
Lordship.
I asked how many days. I didn't ask the date of arrest.
Almost Lordship 9 months Lordship. Actually, I have not counted the days Lordship.
Do you remember how much you got in metric in maths? This is your preparation. You don't know how many days he has been in custody
Yes, Lordship.
and you have come to appear in the High Court,
No, Lordship.
a bail application.
My senior is today hand over the petition Lordship. That is why.
If you're trying to get smart, we can dismiss this application right away. Yes, next.
257
Arising out of same FIR, Lordship, I am co-accused of Sumit Kormakar, Lordship.
क्या order करूँ? Same order. There's the correction code. Yes.
Obilin.
Lordship, the public prosecutor was directed to obtain the instruction whether the service is complete.
Report has not been received. Tuesday, Lordship, I'll take that.
Notice the petitioner is already behind the bar for 265 days today.
Lordship can appoint him.
It may appoint an amicus, Lordship.
Let us appoint the amicus because number of days have been gone. Learned counsel for the petitioner, learned has not been able to obtain instruction regarding service of notice and response from the concerned OC. But to the fact that the petitioner has or it is
Lordship, 265 days as on date.
5 days as on date, I need to appoint an amicus curiae to again on.
Can it be a bit
petition to be
earlier?
served upon the
Can it be a bit early, Lordship? Lordship. Obliged.
Wait, please, Your Lordship. Well, this is POXO matter, my lord. I am in behind the bars for 297 days. The informant's victim's mother and the MO has been examined. Now only the investigating officer is yet to be examined. My lord, the trial court records has arrived, my lord. I humbly urge this honorable court to at least go through the deposition of the victim once. my lord.
Lordship, yesterday we filed our written objection.
W1.
EW1.
Well, they have been implicated.
My lord, here means that there are certain contradictions. Of course, I understand these are a matter of arguments which I will raise before the trial court, my lord. Here I am only praying, my lord, my 297 days, my lord. Only the IO is left to be examined. I humbly pray that I may be set, be allowed to go on bail. Rest, my lord, I'll face the trial and matter of ultimately argument, my lord. In fact, in the again, I understand matter of trial, even the MO.
Lordship, only one PW is remaining, Lordship, and the last date was fixed on, Lordship, on 2nd of August, if I'm not wrong, Lordship. In the meantime, what has happened on that day, Lordship?
The IO didn't turn on the last day. No,
Oh, you're at the fag end of the trial and you have been
That's what I already
fully
told, my lord.
implicated.
I do
So
understand,
there
my
is-
lord. These are all matter of trial and we
There
will
is no
raise.
reason why we should release you now.
My lord, these are all matter of trial. I do understand, my lord. I had already stated at the beginning. There are contradictions which are raised during my argument. But I humbly pray, my lord. Here I am behind the bar for the 297 days. And I am before your lordships, only for your lordships' mercy, my lord. I'm a boy of 20 years, my lord. In fact, in the FSL also, FSL report, nothing conclusive could come out. Your lordship goes through the evidence of the MO.
Are implementing. And one more aspect, your lordship, reside in close proximity with the, there is every chance that the
But our evidence is already there.
for my learned friend is 20. Kindly see page the 34 of the Bell petition.
So it is there, 34.
After point number 14, 14B. All clears at 7 o'clock.
Huh?
Amen. All tears at 7.
Page.
You know, page 34,
34,
down below, he's trying to point out the condition of the hymen, my lord.
It is old tier.
Yes, my lord. And if your lordship now turns to page 35, point number 19 does not reveal any presence of so and so.
Kindly also see point number 6. Injury on body.
These all I will raise before the trial court in my argument. I am here only before your lordship's mercy, my lord.
These are, how can you rely on these injuries? Because as per the version of the victim, it was voluntary. Where is the evidence of age school certificate?
Lord. School certificate को भी हो जाएगा।
Birth certificate.
Not been examined.
Birth certificate was seized. Birth certificate was seized.
Yes.
Of the victim.
It has been exhibited via PW2. The mother.
So age as on occurrence is what?
Occurrence is 25, October 1925. Occurrence is October 18th, 2025.
Plus 15 years old.
All right, we'll see. The thing in your favor is that it is not a case of forcible rape.
Your my lord had already read, but for my own satisfaction, my lord, if your lordship reads the cross-examination regarding the video which she states and regarding that I had asked her not to call, but she was persistently calling me. So these are contradictions, my lord. Which I had already said before I started my arguments.
All right, we'll think about it.
Deeply, my lord.
Charge sheet submitted, looks.
I'm on already interim lawsuit.
Hmm?
I'm on interim lawsuit that may be continued. I will appear in the next. The bail application lawsuit initially further still I was granted bail loss.
What are the sections involved? 80.
Basically, I am selling section 85. The locus of this lawsuit informant, whether she has the locus lawsuit to file this FIR. That is a contention lawsuit. The first schedule itself says that who can lodge the FIR to regarding section 85. And she is a lawsuit stranger, she has no locus to file this FIR. That is the basic ground lawsuit in the FIR. Now my landlord is informed that such has been laid lawsuit, so I have to go by the such lawsuit.
Third, learned counsel for the petitioner and learned additional PP. It is submitted that there is an application filed under so and so. It is submitted by learned additional. The charge sheet in the case has already been submitted. The allegation against the petitioner relates to subjecting his wife to continuous mental and physical harassment, threatening to kill her. The FIR itself has been lodged by person other than the victim. Is allegedly a stranger. Here I'm having the petition. Have you ever appeared before the IO?
I was arrested, no, I have appeared. I was arrested, I was behind the bar before filing this application. And regular bail application.
The interim pre-arrest, this is a bail
Bail
application.
application laws. That is also on the grounds of that grounds of maintainability laws. The locus of the informant on the ground on.
Was released on interim bail pursuant to order dated 30/06/2026. Having regard to the nature of the allegations, cannot be necessary to take the petitioner into custody purpose of the trial. Bail is allowed, the order of interim bail dated hereby made absolute.
Lodge. Deeply obliged.
The Lordship. Lordship, after some time, conducting counsel is on legs, Lordship.
Yes,
Huh?
yes, Metal Lordship.
NDPS. Commercial. Right, let her come.
My please, Lordship. Total 58 days in custody, Your Lordship.
Charge
It was-
submitted. Charge submitted.
Scan copy.
Immediate quantity of ND. Should always submitted. Let's tell also because
Huh?
they can approach in the court below also.
Scan copy may kindly call for, Your Lordship. 58 days already gone.
Immediate, they can, court can grant you bail. You can approach there also.
Considered very recently, Lordship, 24/7.
Charge state mandatory period will not count it, Your Lordship.
Hmm?
TCR mandatory period will not count it. TCR may kindly call for.
The period will not count, but since it is intermediate, since the record is there, they can consider.
TCR may kindly. call for.
Otherwise,
Scan copy of TCR may kindly call.
if you are in custody, you can file the application there tomorrow itself.
Yes.
But if we call for the TCR, you have to wait 2 weeks
Delay will be.
behind bar.
I may allow to approach the direction.
Our learned counsel for the petitioner, learned additional PP submits that the charge sheet has already been submitted by CS number.
120/26 dated 24/7.
Learned counsel for the petitioner submits that since the matter involves intermediate quantity only and he has spent about 58 days behind bars, he shall approach the learned trial court. The instant petition stands closed. Yes.
Obliged.
Same order, Lordship, charge sheet submitted.
May I please, your Lordship.
Intermediate.
Intermediate quantity, my lord. Actually, from our possession, my lord, it is a small quantity because 3 persons were moving around a house, my lord, and 1.27 grams of suspected heroin was recovered from the 3 numbers of accused. And subsequently, on search of the house of the other persons, other quantity was recovered. So from us, it was a small quantity. However, the case is registered under section 21B. It is intermediate.
Charge sheet submitted on 11th, Lordship. Let them approach.
So go apply there. Charge sheet number.
Charge sheet number, Lordship, 71/26 dated 11/8/26.
Same order.
Obliged.
Number of days to বেলেগ হবো behind bars. Number of days 58 to it will বেলেগ হবো. Date of arrest to silo. Yes.
Yes, my lord. I am the more than 6 months, my lord, inside the jail, my lord. And the statements of the co-accused may kindly be used as called for last date, my lord. I'm not in any way connected with the LS documents, my lord.
Yes, PP.
Case Lordship.
Huh?
Murder case Lordship.
Murder.
Murder. And Lordship charges were framed on 23/6.
What is the name of the deceased?
My lord,
Name of the deceased?
name of the deceased, my lord. But police station is there.
Same report Lordship I have flag mark.
FIR not. At Imran Hussain. Was a policeman, my lord. The whole incident has been made the videography later on, my lord, under the instructions of the accused, my lords. How they have committed, my lord, the accused.
Charges were framed on 23rd of June. And thereafter, Lordship, it is fixed for evidence. It has not yet started. Lordship, I have flag mark one important witness, that is Mukut Ali. I have flag mark. He is the eyewitness. And Lordship, based on his statement, TIP was also done, Lordship, on 23/4/26. And there, this Mukut Ali, Lordship, he identified the petitioner.
Lords, at that time I was in station, my lords.
That
And
statement may be
the co-accused.
Who is he? He is a
Yes,
CRPF personnel.
yes,
He must have been in the train.
yes, because they were unidentified, Lordship. So TIP was also done.
That is all right. He has identified him, but apparently from the statement of the accused,
Yes,
main accused,
yes.
yes, that he had no role.
But Lordship, yes, that is Lordship.
He inculpated himself, but
My lord,
That is there.
I had no any knowledge about it. Later on, I have came to know from the main accused, my lords. That's under the circumstances that he has
They are not
committed
the
that
residents of
offense.
here, Lordship.
My
That
lords,
is one
my
thing.
lords,
Second, evidence have not yet started. So that's the only, they are not the residents of the state, Lordship.
my lord, on any conditions, my lords, I will fully
If-
cooperate with the trial proceeding, my lords. No further custodial detention is required, my lords.
what is the charge against him? The charge sheet. What is the charge against him?
Charges have been framed under,
No, what act has been attributed to him in the commission of murder? I think this will be a good case for discharge, providing the learned counsel representing him chooses to argue for a discharge, which I have rarely seen. Learned counsel for the petitioner and learned PP decision application under so and so. The allegation paragraph 2. The scanned copy of the TCR has been received. It appears that the charge sheet has already been submitted. The material available on record prima facie attribute any role to the present petitioner in the commission of murder of the deceased. Regard to the of the prayer for bail is allowed according is on bail of rupees 3,000 with securities, 2 local securities of like amount, the satisfaction of the trial court. Further provided that the petitioner here before the court as and when summoned participate in the trial. One commences against him. Petitions allowed accordingly.
Last minute.
Item 60 has been, by this, our RJ Burwal Lordship. Can it be after some time, Lordship? It will be just around, Lordship.
Your Lordship, in this case, Lordship, a scanned copy of the trial court record was called for. As during the pendency of the regular bail application, charge sheet was filed. The petitioner was arrested on 27/6 and today is 48 days, Lordship. Section 12 of POCSO Act. 183 is there, Lordship. I have flagged it.
Not follow properly. What did she say?
See, only touching part is there, looking at her, Lordship. He's saying that the teacher asked her, have you taken your lunch? Then he was staring at her. I have seen in 183 that much only, Lordship. And in the FIR also they have, but the thing only is that he was a teacher.
Counsel for the petition and additional PP.
7 years.
Heard, Mr. From anything to say?
Sir, my lord, up to lordship.
There is an application under so and so. CD as called for has been received. Perusal of the same as well as the statement of the victim recorded under 183 BNSS. The view that further custodial detention of the petition not necessary, accordingly prayer for bail is allowed. 20,000 2 securities. Inspection of
Special Judge Gwalpara.
Special just POCSO, Goalpara.
I'm deeply obliged.
May I please watching it? Can you take it after some time, madam? Obliged, madam.
May please your lordships, regular bail application, my lordships. The petitioner was arrested only 317 section, my lordship, dishonestly receiving the stolen property, my lordships. Actually, my lordship, he is totally innocent, my lordships. The accused person was arrested on 28.
Call for lordship.
My-
Reminder এটা দিও।
My humble prayer, lordships, is behind the bar about 15 days, my lordships. By imposing any condition, he may be allowed to go on bail. Only 3 years imprisoned, my lordships. Dishonestly receiving of external property. Only he was arrested on 317 subsection 2, arrested, my lordships. By imposing any condition, I will face the trial, my lordships.
As sarcited lordship, TCS is
Sarcited,
called
ma'am.
for lordship. So reminder may be given lordship.
Here is called for has not been received.
Lordship, my humble prayer, lordship, direction may be given to the appear before the trial court, my lordships.
Always appear. Counsel for the prisoner submits that the. Here means what, you are behind bars.
Behind bar, yes, my lordship.
Will apply for bail there.
Apply for bail,
Regular bill.
regular bail, my
Will
lordship.
apply for regular bail as the charge sheet has already been submitted. It's closed. Yes.
Highly applicable.
And a similar case is fixed on my lord, 27, my lord.
Please tell them wait.
Document 1161. 26, my lord. AB 1161, my lord.
On 27.
1161 and 1197. Then intimate of that may continue.
Same past earlier to continue.
Even similar fiction.
27. On a similar, same, my lord.
27.
27, 8. Deep level.
Yeah, please, your lordship. Lordship, my lord, granted bail, my lord, I'm duly appeared, my lord, I have not violated any condition of the bail of the lordship. Lordship,
Lordship-
granted this bail, my lord,
CDS 34.
non-furnishing of 35 notice, lordship. I'm cooperating.
Lordship, in this case, lordship, they have appeared lordship, but the thing is that the driver lordship, who is the accused main, he have implicated their names, lord. That he has admitted that he was in the stolen the pipes lordship, but along with this 2% lordship. In lordship may Paris lordship.
They're only handyman, my lord, on being called lordship, I was.
And this 2% were earlier also doing this type of things lordship.
Cooperating, my lord. Thirty-five notice has been issued, lordship.
Pipes were seized lord.
He has in fact not only implicated but blamed them.
Lordship.
তাহাঁতো তাৰ পৰচনত পৰিহে এই কাম কৰিছিলো।
I think it's the initial stage also because I have not gone through the other witnesses, Lordship. Complainant statement is there and Caesar witness
We
and
will see then you, if you have anything else to mark, you can hand it over. We'll see that.
Lordship.
36 मतलब similar.
Similar, 36,
And 36 मतलब similar.
34 and 36.
All right, this is the other fellow.
Both are handyman.
10 copies.
Please, Your Lordship. The chair was called for, my lord. The chair received the service report. This is FOXO case, my lord. Service report from the.
As I'm also speaking.
Huh? Sir.
My lord, that is completed, my lord. We receive one communication.
Here at page number 9. Is that the choose number 1, my lord, on the pretext of marriage, abducting the sister of the informant and kept the whole night in his house and committed, my lord, sexual assault. Allegation, my lord.
I'm having difficulty reading this. What has he said?
My lord, service completed, my lord, as because FOXO is there, amicus may be appointed, nobody is appeared, my lord. Otherwise, we received the, my lord, that is that. Or that may be fixed, my lord.
Service completed.
Completed, my lord. I have, my lord, submitted one, my lord, communication.
TCR has been received along with statement of victim under 180, section 183 BNSS. Medical report. Service on respondent number 2 is complete as submitted by learned additional PP. However, none appears on behalf of the said respondent. And so is appointed as amicus curiae to represent respondent number 2. Extra copy be served on the appointed amicus. This again on is.
Left.
PRS bail application, my lord. PRS bail application, my lord. This is 21B of NDPS Act, my lord. Nil quantity, my lord. Here, the lordship will find page 15 is the FIR, my lord. Page 15, man. In this case.
Page 15, 1-5.
1-5, man. 1-5. Here in this case, my lord, the person who was arrested, my lord, in a Naka checking, he was riding on a bike and the contraband was recovered from a nylon bag. He stated my name. The allegation is that, man. My role is that. He stated my name that I had given to him and he was supposed to deliver it to some Raja, my lord. That is the allegation, my lord. Otherwise, the contraband is not even recovered from my possession. I'm nowhere connected, my lord. Only on the basis of his statement, my lord, police is looking. Last occasion, diary was called for, my lord. I am Sirajul Haq.
Yes.
And in that statement, my lord, nothing is.
Statement is squarely implicating.
That is, my lord, thoroughly implicated. In my lord, later part also, my lord, there is the transaction amount is also, my lord, mentioned, my lord. Otherwise, my lord, the 7 matter, my lord, the 726, my lord. Otherwise, my lord, it is FIR is lodged on, my lord. This is, my lord, 9/7/26. Okay, my lord, tried to, my lord, find him.
I will cooperate with the investigation. I'm ready to cooperate with the, even it is in the nascent stage also, my lord. Ready to cooperate with the investigation. Only on the basis of the statement, my lord. If you find page 16, my lord, the operative part where my name.
It is enough to implicate you.
My lord,
And who else will say?
co-accused statement, my lord. My lord knows, my lord, on the basis of co-accused statement, my lord.
Don't know. Recently, another decision of the Supreme Court has been submitted by one of your colleagues. Said that in pre-arrest it will not be this Tufansing and all principle that will not be applicable in case of pre-arrest bail. Very specifically it has been stated. That means the statement can be taken into consideration.
Middle quantity, my lord. Small, my lord, middle quantity, intermediate quantity, my lord. 20.
All right, we'll see. B stands on a different footing.
Apart from, my lord, the co-accused statement, one learned friend is.
Yes, we have noted that.
My lord, that is the only thing. Otherwise, if other materials, my lord, learned friend said there's no other materials, my lord, against me. But only this statement, my lord, in the FIR. That is the thing. Considering that aspect, my lord, and intermediate quantity, my lord, lordship. I'm ready to cooperate with the investigation. Highly applied.
May it please your lordship. And the petitioner is behind intermediate quantity, lordship. 3.8 kg of ganjas, lordship. The petitioner is a lady of 31 years of age, lordship. Today is 36 days, lordship. She is a mother of minor children, lordship. And notice under 48 was served to her minor child, lordship. Forwarding at page 14, lordship.
My lord, otherwise CD not received, my lord.
Forwarding page 17, lordship. This wrongly reflected here 10 June, Lordship. He was arrested on 9 July, Lordship.
9 July and 10 June.
Lordship, it is wrongly reflected here, Lordship, in the forwarding report, Lordship. Actually, she was arrested on 9 July. So 36 days, Lordship. Here it is reflected 10 June, Lordship.
Let the CD come.
Lordship, 36 days, Omen, Lordship. Kindly produce the 48 notice,
We are
Lordship, for
rejecting
once.
even in 56 days. Yes. Let the CD come. We have stopped being so lenient in NDPS cases.
Husband also arrested, Lordship.
Yes, should be.
Children are suffering.
Now you remember your children. When doing the business, you don't remember the children of other people.
48 notice also served to her minor child, Lordship.
Can't say without the CD. Who is minor,
Monday,
who is major.
Lordship. Lordship, can it be on 21, Lordship? 21, Lordship. 21, Lordship. Oblige, Lordship.
I please Lordship. Application under section 528 of BNSS for passing the search sheet of 186 arising out of Hazu PS case number 464/24. Let's see, FIR is in page number 10.
Where is it listed for order?
That's it.
Service of respondent number 2 is still awaited. As per office note. Service on respondent number 2. It. Taken by speed post.
That's it.
Where is the address? This is Hajo, through police station also you can take.
That can. Otherwise, my lord, here, my lord, section, my lord, POCSO is not there. Or what's it can, my lord?
He has made him a party.
Ah,
Application filed on the basis of compromise agreement. That's it.
That is why he should come.
then it should come, my lord.
Can take fresh steps if take fresh steps. List again on.
Highly advised.
Yes. Allegation. Setup कराले next case to माटी देख बाकी दुटा time लगेगा
PCR have arrived, Lordship. Last location, Lordship. Ten years punishment have been imposed upon the appellant, Lordship, and out of which, Lordship, they have already undergone 8 years, 3 months, Lordship. They Fix the
Which will
case.
fix it for hearing on.
Yes, in the meantime, Lordship, call for a report from the central jail, Lordship, whether they are in the jail. I have no information. These are legalate matters, Lordship. Jail appeal.
Learned Legal Aid Council and Learned LPP. Here has been received. This is a matter for hearing. In the meantime, call for a report from the superintendent. Which jail?
Central jail, Gauhati.
Jail Gauhati as to whether the appellant Ranjan Sarkar and
Jon Sarkar, Madhu De, and Akash Majumdar.
all three, okay, are still lodged in Central Jail Gauhati.
It was such a fixed for hearing. It just come on orders for long. That come up for hearing loss.
Matter is longly listed for orders. List the matter for hearing again on give a date.
Can it be 26, Lordship?
Out.
27 August. Search. Publish.
Please, Your Lordship. This is a criminal jail appeal. There is one suspension of LCR has already been received.
Who is amicus? Who is the amicus appointed? Pretty Das. Am I shown? Oh. Yes, it is shown. What to do?
Otherwise, this year receive.
Huh?
Third date, third date.
You inform the amicus also.
Your Lordship. Next week, already LCR has been received.
Same order as the order, last order is the matter. Again on. So fix it for hearing.
Can listed for hearing also.
For
Long
hearing.
5 years.
Hearing. For hearing. So it's-
Lordship, on the earlier occasion, Lordship had directed us to take fresh steps. Accordingly, same has been taken, my lord. From the service report, it appears that it is still awaited, my lord. Matter may come up after 3 weeks, my lord. Let the report come.
Petitioner has taken steps pursuant to the last order. Report of service is still awaited. Hence list again on. 3 weeks. 3 weeks.
Please to me fix it. Oblige me.
May I please, your lordship?
Yes.
My lord, it was once rejected, my lord, earlier before the charge sheet. Now charge sheet has been filed. The page, my lord, 24 is the FIR. But the earlier, what happened, my lord? This is the case, my lord, initiated by the one purported, my lord, informant. He is no way connected to the victim. Though he claimed to be uncle, but he is not the uncle. The victim doesn't have any uncle. And the mother has also testified. Father has already died, my lord. Last time nobody appeared on behalf of the informant. And the lordship appointed one amicus, my lord. Now, this time also, my lord, we have served the notice to the mother and the victim. And probably, my lord, they have appeared, they have filed their reply also, my lord. And the charge sheet also and the witness.
Yes.
Well, the case before your lordship is, our case is that it was instigated by the earlier informant. And accordingly, the victim, he has narrated the story at the dictation of the informant. But later on, mother has testified now that it was a false instigation on the basis of the false, my lord, some allegation, my lord. And the victim was accordingly tutored and he testified, my lord. Now, mother is a witness to the case also. This charge sheet, my lord.
They, who has filed objection? Informant.
Now,
have
my,
filed
not
something.
informant, my lord, mother of the,
Number two, madam.
mother of the victim, my lord.
Father of the victim.
Mother of the.
Mother.
Mother.
You have filed any?
Father already expired.
I have already filed, madam.
Father
Informant
is
did not
expired.
appear.
Who are you appearing for now?
Informant did not appear, my lord. The last occasion.
Informant was who? Rohima Khatun.
No, my lord. Informant is Rakibul Islam. He claimed to be uncle, but he is not an uncle, my lord.
What is Rohima? What is the stand of Rohima Khatun?
But I have inquired about the incident, my lord. He told me that no such incident was. Moreover, my lord, informant also not related to us, my lord. I have clearly stated, my lord, in paragraph number 5, 7, and 8, my lord.
Yes, anything to say, PP?
I don't know the successive bail application, my lord, earlier rejected, my lord, and on the last order I have perused, my lord. One amicus was appeared for the informant, my lord. Now there are new grounds is paragraph 16 and 17 of the bail application, my lord. There are the new grounds, my lord.
The last occasion also, we had the same plea that it was a false case, my lord. But as the victim has implicated, Lordship was pleased to, but this is the new circumstances now. And the charge sheet also laid, and these circumstances now,
I am sorry, 10 and 11, my lord.
So the position is victim had implicated, but mother has now said something
After
else.
repaired and my lord, mother has filed an my lord, affidavit, my lord, not, it's an objection, my lord. This is a my lord, affidavit, my lord. Yes, settled, my lord, that she does not have any objection, my lord.
moreover, my lord, I am more than 90 days in the custody. Okay. About 90 days.
But the member-
Initially also, we had the same stand, my lord, that this is a false implications, my lord.
Senior counsel for the pit. Said by so and so. Learned additional. Learned mother of the vic. This application under so and so. Allegation pertains penetrative sexual assault upon a minor girl by the petitioner. An earlier bail application on behalf of the petitioner by this court, perusal of the CD. The instant bail application, affidavit has been filed by the mother of the victim, stating that the informant of the FIR
Raqibul Islam.
of this case,
Rafiqul
which is Raqib Islam, who is neither related to the victim nor his natural or legal guardian. That such stated in the said affidavit that no such incident as alleged has taken place, and the allegations were made on the basis of misrepresented facts as tutored by the informant and other interested. Also stated that the section if bail is granted to the petitioner. There having regard to the above, as well as the period of detention of how many days?
Nearly 86 days.
86 days. Prayer for bail is allowed. Petitioner so and so is on bail of rupees 3,000 with 2 securities of like amount to the satisfaction of the credit of the petitioner for it in the trial if one commences against him and will not try to influence or intimidate any person acquainted with the facts of the case.
Obliged, highly obliged.
And allowed.
Member.
Lordships.
POCSO, my lord, service completed, my lord. We received a, my lord, report, my.
Is completion.
This is criminal petition, isn't it?
Yes, my lord. In this case, my lord, the Learned Trial Court, my lord, submitted charge sheet, my lord, against the petitioner, my lord, as showing him as the absconder, my lord.
The service is complete, we list it for admission then.
My lord.
Learned edition or learned counsel for the petitioner, learned additional PP submits. That. Part 2 has been duly served and in this regard has furnished the communication of the C. Kanpur PS Nagaon dated 5/8/26. Kept on record. The matter for admission. On
Obliged, my lord.
Yes, your lordship. I is for correction of typographical error, your lordship.
yes, what is the error?
Lordship. Lordship, page number 18, your lordship. Instead of 4,000, it should be 6,500, your lordship. It's wrongly typed, your lordship.
Which paragraph?
Paragraph 9, 11, and 12, your lordship. Paragraph. Page number 17, your lordship. Para 9. And last line, your lordship, from rupees 9,000 to it should be 6,500, your lordship. I have annexed the order of the appellate court also, your lordship. Page number 7. The order of
In the present order, which starting from para?
para 9, 11, and 12.
Wait, let's go to 9 first.
Para 9. Page number 17, your lordship.
Yes.
Last line, your lordship. Reducing the amount of maintenance from rupees 9,000 to rupees, it should be 6,500, your lordship, because the appellate court has directed the husband to pay 6,500, your lordship, to the wife.
From 9,000, it was reduced to 6,500.
Lordship. I have annexed the order also, your lordship. Appellate court order.
Then para
and para
11.
11 and 12, your lordship. Page 18. Third line, your lordship. Interim maintenance from rupees 9,000 to rupees, it should be 6,500, lordship.
No, which line?
A third line, your lordship, page 18. Page 18, third line.
Para 11, there is at page 18.
Lordship, third line. And also the last line of para 11, lordship. Last line of para 11, as would lead this court to reduce the amount of rupees, it should be 6,500, lordship. Para 12 also, your lordship, a second line, lordship. Rupees 6,500 it should be.
The second last line of para 11.
Lordship.
Then para 12.
Para 12, second line, lordship. Appellate court, no question of enhancing the said order of rupees, it should be 6,500, lordship.
Third learned counsel for the petitioner.
SNL-PP. This IA has been preferred seeking correction of certain errors that has crept into the order dated passed by this court in the criminal revision petition number 9 of 2020. Stated that the figure of rupees 6,500 that the figure that in the paragraph number 9, 11 and 12 of the said order, instead of rupees 4,000, the amount should be rupees 6,500. Of the record, it appears that the figure has been erroneously mentioned as rupees 4,000, which is required to be corrected as rupees 6,500 aforesaid paragraphs. It is that the figure rupees 1,000 appear in paragraphs 9, 11 and 12 of the said order shall be read as rupees 6,500 form part of the stated video casting. I stands disposed of.
Deeply obliged, Your Lordship.
Here the scan copy was sought for, my lord.
Lordship has already had this matter, my lord. Only, my lord, on the last occasion, my learned senior friend has submitted it, my lord. The victim has already been stated, already been examined as a PW1, my lord. So, my lord, the second copy was called for, my lord. But I have perused the second copy of the record, my lord. That is not there, my lord. The evidence of the
We have certified copy, my lord. We have certified copy.
Why did you call for scan?
On the last occasion, lordship called for it, my lord. Only there is a mistake, my lord. Now we said that 9 witnesses were examined. 9 witnesses were called, 9 came, 5 have been examined, including the mother, the victim, and my lord, the co-students, my lord. We have the certified copies, my lord. But if I read it and I'll place it before your lordships, my lord. And I initially said, my lord, that the first informant, she being the headmaster, was at loggerheads with the teacher, my lord. And it is apparent on reading the evidence of even the victim and the mother of the victim also, my lord. That and 67 days in, 56, 7 days in custody, my lord. Copy to dear. It only one negative. PW1 is mother, my lord. Certain parts are very important, my lord. That the victim girl, that she was propped up by the principal, my lord. It is apparent, my lord, because she never told the mother at home or anywhere else, my lord, with all respect, my lord, regarding, my lord, anything sexually implicit, my lord. May I just read the victim 1, my lord, only the relevant lines, my lord. We have marked it, my lord. Mother of the victim, my lord. The victim never told the mother at home about these activities any point of time, my lord. And whatever was done. PW1, my lord. May I the last parting paragraph, my lord. Lordship may have found, my lord. First page.
Yes.
PW1, my lord. When police came to our house few days ago, I asked the victim why police came to our school. The victim told me that accused Dilbar assaulted her physically and hit her on her back, and also that accused scolded her. Victim further told me that due to the said scolding and assault, the accused, she remained absent in school during the above days. This is one story, my lord. That due to the beating, and this is said, my mother, no? By the mother of the victim, my lord. And thereafter cross-examination, my lord. Lordship, I have found, my lord.
Yes.
Prior to lodging of the first prior to lodging of the FIR, informant did not incur about any occurrence with me or my husband. Parents were never asked by the principal, my lord, who is the first informant at loggerheads with the present accused. I do not know if prior to lodging of the FIR, informant incurred with the victim about the occurrence. We respect the accused as a teacher of the victim. My lord, this rest are possibly not very of much importance, my lord.
Yes.
Thereafter, my lord, next page, my lord. This is very important, my lord. First line, second line, third line, fourth line, fifth line, sixth line. I heard that a dispute is going on between the accused and the informant. Accused is a teacher, informant is the, my lord, the principal, my lord. Last parting line, my lord. Till date, victim has not told me that accused Dilbar Ali established any sexual activity with her. This is the mother, my lord. Next page is the victim, my lord. Victim, last paragraph, my lord. Dilbar sir used to give me bad touch. By bad touch, I mean he used to touch me at my waist and with bad intention, and also used to kiss me on my forehead with bad intention. In classroom, my lord, above others, that comes subsequently. Next page, my lord. There is another allegation, my lord. One day when I was studying in class, Roman 2? Class 7, in Sage School, Dilbar sir came to our house in absence of my mother. At that time, my paternal grandmother was at our home. Dilbar sir then asked me to close the curtain of the room on which he sat. I refused to close the door and told him that I will call my parental grandmother. Dilbar sir then told me not to call my grandmother and asked me to close the curtain and sit near me. But still I went to call my grandmother, and when I came back to the room, I found Dilbar sir already left our house. This is my lord, mother was never told. Next page, cross-examination, my lord. I know, my lord, third paragraph. In Sage School, both boys and girls study. In our section of class, there are about 40 boys and students, about 10 girl students, including me. Dilbar master used to kiss me and touch me in our classroom in presence of all the students. Kindly see, my lord. Thereafter, next page, my lord. First, second, third, fourth, fifth paragraph, my lord. There is a student in our Sage School. The body of the students in our school dissolves annually. I never informed members of our students' union about the alleged bad activities done by Dilbar sir with me, inclusive of mother, not told prior hand. Definitely the first informant, my lord. I know Mona Lisa madam, who is a teacher of our school. I did not tell Mona Lisa madam about the alleged activities done by Dilbar sir. There are girl students in class so-and-so in our school who are senior to me. I did not inform these seniors office the alleged bad activities done by Dilbar sir with me. Next page, my lord. I never informed principal sir of our school about the alleged bad activities done by Dilbar sir with me prior to the date when I and my friends went to sir for informing the matter. Thereafter, my lord, leaving aside 5-6 lines. Principal sir did not tell me that he lost an FIR. Sir did not tell me about the content of the FIR till date. This is the victim statement, my lord. These are of not much importance, my lord. Other co-student statement, my lord, that I am reading out, my lord. Definitely, my lord, the principal has a role to play, who happens to be the first informant. PW3, my lord. Who know it? Another victim, Alice victim, my lord. Lordship may have found, my lord. I heard that Dilbar Ali used to pull urna of the victim. Dilbar sir touched my waist. Dilbar sir also used to touch body of our other girl classmate. This is another victim, my lord. A list. Thereafter, my lord, next page. From the last line, my lord, first, second, third, fourth paragraph. Victim in presence of principal sir. This is very important, my lord, tutoring. Victim in presence of principal sir told me to give evidence in court in her favor. In her favor, it was to be told. This is one girl student saying, my lord. This shows that her statement may have been tutored also, my lord. And my lord, the first line and the second line is very important of the co-girl student, my lord. All the students saw Dilbar sir touching our body. Nothing sexually explicit, my lord. All the students saw Dilbar sir touching our body. Victim in presence of principal sir told me to give evidence in court in our favor. Apparently, they are at loggerheads. Mother has also said, my lord. PW4, my lord. It student. He is also a student, my lord. See, a lady student, my lord. Dilbar sir used to touch inappropriately on shoulders and arms of all the girl students in our class. Must have been tutored, my lord. Touch, my lord. This much, my lord, and thereafter, the race may not be of much importance. And my lord, witness same witness, my lord, towards the end, my lord, when I reported the matter of inappropriate touching of Dilbar sir to my parents neither reacted nor gave any complaint to principal sir. PW5 said, my lord, Dilbar sir asked me question in connection with her subject, and when I gave him correct reply to his question, he tried to touch my chin, but I stepped back, due to which he could not touch my chin. This much, my lord.
My lord, as part of the charge sheet, my lord, there are total 14 numbers of witnesses, my lord. And my lord, till now, my lord, on 3rd, 4th, and 5th of this month, my lord, 5 witnesses have already been examined, my lord. And PW, my lord, 2, 3, 4, and 5, my lord, they are all the victim girl, my lord. The main victim girl, and PW 3, 4, 5 also other victim girl, my lord. We have, my lord, implicated, my lord, that the extent of, my lord, touching part, my lord. My lord, at this stage, my lord, this is a bail application, my lord. So at this stage, my lord, it is not necessary to, my lord, go to the entire evidence of the, my lord, victim, my lord, what they have stated in C, my lord. Only prima facie matters, my lord, lordship will look. I have perused the, my lord, the evidence of victim, my lord, that because examined as PW2, my lord. First, the accused person touched her waist, my lord, and tried to kiss her on her forehead, my lord. And the other, my lord, other PWs also, my lord, they have stated, my lord, in C. The accused person, my lord, tried to, my lord, touch her, my lord, waist, my lord. Basically the waist, and tried to kiss her in their forehead, my lord. That is implicated, my lord. It's clear.
Statement to person.
If lordship
How many
peruse the
PWs?
bail
14 are
application, my
there.
lord,
14 are there.
my lord, total 14, my lord.
5 examined, my lord, kimanta thakibo? 9ta thakibo nohai aru. My lord, 9 came to court, 4 were not examined, discharged, my lord, temporarily, and thereafter, my lord, 5 were examined, my lord. Now, my lord, I am putting reliance on this, my lord, the mother's statement. If a girl, the prime victim, my lord, with all respect, my lord, if something really happened, bounden duty of the girl, my lord, first telling the parents. And this line is of much importance, my lord. There will be ultimately conviction or not, my lord. My lord, it all assets. Till the date of deposing, my lord, last part of the mother's statement. Till date, victim has not told me that accused Dirbal Ali established any sexual activity with her. And prior to that, while it is important, my lord, I heard that a dispute is going on between the accused and the informant. Informant happens to be the principal, my lord. And my lord, the touching part was carried out. So far as the victim and others are concerned, my lord, the rest are of not much important. Chin and soldier, my lord. I said school, both boys and girls study. In our section of class, there are about 40 boy students and about 10 girl students, including me. Dilbar master used to kiss me and touch me in our classroom in presence of all the students. Can there be something sexually explicit, my lord? This much, my lord. And he is there for 57 days, my lord. And the certain witnesses are yet to be examined for his instruction. And my lord, tampering does not arise, my lord. That would be dangerous for him, my lord. And my lord, whatever has been told by the other girls, this line is sufficient, my lord, regarding mother's statement that she never, the victim never told, the prime victim, my lord, she never went home. All these days prior to her deposition, my lord, it was not disclosed before the mother. That is very unusual, my lord. So the first informant must have played a role, my lord. 1.5 years of service, my lord. Whether further detention is necessary, my lord, with all respect, my lord. Lordship will peruse that letter and pass appropriate order, my lord.
Yes. Amicus is also present, my lord.
Yes, anything to submit?
Lordship, my only submission is that he is in a very influential position being the teacher. So might influence the witnesses who are yet to be examined, Your Lordship.
Influence part is over, my lord, because the principal is there, who is the first informant, my lord.
About the witnesses, Your Lordship.
Principal is there in school, my lord. This much, my lord, Lordship kindly peruse that later, my lord, with all respect, my lord. My lord.
I'm 41.
My lord, is a criminal petition, my lord. It will take some time for hearing, my lord.
I will take up at 2 then.
My lord.
Continue.
May I please, my lord?
Other side is on the line.
In this matter, my lord, otherwise petitioner in person who is appearing, my lord. So today, I think, my lord, not present, my lord.
He's appearing.
Is appearing through VC or in person?
It seems from BC.
Last
Lordship.
time. Yes, yes, it is there. Yes, you can begin.
Yes. My lord, this criminal petition, my lord,
We are taking up for final disposal, isn't it?
my lord, my lord, my lord, my lord, since there is no protection, so my prayer, this may be disposed finally, my lord.
Lordship, I would humbly submit that I challenge this criminal petition on the grounds of maintainability first. This petition has to overcome the grounds or the threshold of maintainability.
He is the petitioner. He has the right of first hearing, so he will submit first.
Lordship, I would on. I would on.
My lord, this criminal petition, my lord, this has been filed under section 482 of the Criminal Procedure Code, my lord, praying, my lord, basically for setting and quashing the, my lord, impugned order dated 2/6/2023, passed in police PRC case number, my lord, 878, whereby the learned judicial magistrate first class took the cognizance of the offences under section 468, 471 of the IPC. On the ground, my lord, first is that no reasons, no judicial mind has been exercised, my lord. It has been mechanically passed, my lord, and it is quite evident from the order itself, my lord. Because, my lord, issuing summon, so far the settled proposition of law, my lord, as held by a series of judgment, my lord, that some exercise has to be done. Some issuing summon, it is not something mechanically it has to be issued. First, it has to be seen whether there is a prima facie case to proceed further with the case. Some sort of exercise of mind should be there in the order itself. There only after someone has to be issued. Because issuing someone is considered as a very serious matter, my lord. So, my lord, first ground, my lord, this has been mechanically issued, my lord. There is nothing, no exercise of the judicial mind from the order itself. It's so apparent, my lord. I will demonstrate with that one while reading the MP order. Now, my lord, thereafter, my lord, I am also praying for the entire quashing of this particular PRC case, FIR along with the charge sheet, my lord. Reason, my lord, on the basis, my lord, there is no prima facie case, my lord, because the allegation is that the document was forged, my lord. But from the charge sheet, my lord, it is so apparent, my lord, that prosecution, the investigation has failed to collect any evidence, my lord, showing that my involvement in forgery of the document, my lord. This official report is negative, my lord, and apart from there is no any materials, incriminating materials, where I can be, my lord, alleged to have involved in the commission of this particular forged document, my lord. Apart from there, my lord, apart from this prima facie, my lord, the another ground is, my lord, there is a bar under section 195B, 1B of the CRPC, because the allegation here in the FIR is that while moving the pre-arrest bail application, the petitioner allegedly used forged document. Now, my lord, when such allegation and the investigation charge sheet says that the alleged forged document, it was done within the court premises, place of occurrence in the charge sheet, it is shown that it was done within the court complex. Now, my lord, if that is so, the requirement is that under section 195 1B of the CRPC, my lord, when the any crime is alleged to have done against the administration of justice, my lord, then the private party has no locus to file the complaint. And even if file the complaint, my lord, then cognizance cannot be taken up because the procedure is prescribed under section 340 of the CRPC, where it says that first inquiry has to be done, and only on finding that this is a case to proceed further, then only complaint has to be filed by the concerned authority concerned. Only thereafter cognizance can be taken up, my lord. So these are basically, my lord, in nutshell, my case, my lord. Now, my lord, I would like to apprise my lord about the relevant facts, my lord, under what circumstances I am alleged to have forged this document in the FIR itself, my lord. My lord, basically the petitioner is a, my lord, businessman, my lord. He is a contractor, my lord, basically. So what happened, my lord? It was somewhere, my lord, in the year 2016 or 17. Petitioner, my lord, got some subcontract work. It is somewhere in the Upper Siang district in Arunachal Pradesh, Yingkiong, my lord. So I was in look, the petitioner was in look for some excavator, my lord, heavy machinery. The contract was for, my lord, cutting the earth, cutting road, cutting, my lord. So at that point, I was looking for it. At that point of time, the respondent herein, who is in person, his already excavator were already deployed and were being used by some other company at that point of time. That was nearby the construction side of that, nearby the project side only, my lord. So, my lord, then this petitioner in person, my lord, then we came to in touch with telephonically. He also informed me that he has a, I was in my resident Doimuk, my lord, at that point of time. Telephonically informed me, my lord, that 4 nose of excavator, it's there available in the construction site. So accordingly, my lord, we met in Silapathar. Silapathar, my lord, we met there. Then, my lord, this lease agreement was drawn, my lord. Now, my lord, one very interesting thing, my lord will note here. Now, after all this problem when it started, then this petitioner person is saying that this excavator, all this thing doesn't belong to me. It belonged to his mother, my lord. Very interesting, my lord. So as on today, I have never met her mother, and moreover, very interesting, this complaint has not been filed by the mother. This case has not been prosecuted by the mother. Altogether, this petitioner's person who is saying that this, he is denying that this agreement was not signed with me at Likhavali. Now he is saying that I entered with agreement with his mother at Dibrugarh, my lord. Very interesting, my lord. Now, my lord will say, find, my lord, nowhere his mother is there. Neither the complainant, neither nothing, my lord. So at that point of time, I was not informed about who is the owner of the excavator. The petitioner is respondent. He represented himself as he is the owner of the excavator. That's why he has all the knowledges, and say that all these 4 excavators are lying there. Then, my lord, we agreed. Payment was given. There is a record, my lord. Payment was given at his instruction to one, my lord, Ashish Kumar Agarwal. During investigation, check number also given, my lord, check number 2425, 14 lakh rupees advance payment was given. At the instruction of the petitioner in person, my lord, 14 lakh rupees check advance amount was paid, my lord. Certificate to that effect, my lord, was issued by this Ashish Agarwal also, my lord, that in which manner he received the money and how that money was used at the instruction of the respondent here in, my lord. Now, after that, my lord, this rental agreement, it was executed on 21/2017. Under this agreement, my lord, with this agreement, may I take to my lord to agreement, my lord? Kindly turn to page number 24, my lord.
Of the
Criminal petition, my lord. My lord. It's the type copy is that, my lord, annexure 1, page number 24. And page number 25 is the written copy, my lord. 24, my lord. So this is the rental agreement, my lord. And as per this rental agreement, I was supposed to pay 14 lakhs rupees, which I paid. From my bank records also, my lord, it established this check in the name of Ashish Agarwal. And, my lord, here shall keep there during the period any kind of will be by the lessor and also the seller. Then in the terms and condition here that the lessee shall maintain the rent equipment during the terms of any kind of repair and maintenance will be there. So in case of some major problems happen to the excavator or something, that maintenance amount, that everything will be borne by the petitioner in person, who is the respondent here. And here, my lord, he represented himself as the owner of the excavator. His name is Manish Agarwal here, my lord. Nowhere is mother, my lord, question, my lord. And till that, my lord, I have not met. Never seen her mother, my lord. And I don't feel that mother would come and, my lord, and make the agreement with me. And she has not been pursuing this matter, this case altogether, my lord. All this, he is only the respondent. He has been pursuing the matter. The original owner is nowhere in the scene, my lord. From there itself, we can infer, my lord, that he was the person altogether. He was doing all the business, though the name of the machines may be in his mother's name, but he was the person doing all the businesses, everything, not his mother. Then thereafter, my lord, what happened? Thereafter, what happened? This some of the excavator, since already that was used by the earlier contractors, my lord. So I was not informed fairly, my lord, that condition of the excavator. So when I went there, I found that out of the 4 excavator, one of the excavator was not in completely condition, because that was already in use nearby the site project, my lord. It is not something I took the new excavator with me, my lord. No, that was already used by other contractors, and from there only I take. So 3 of the excavator I repaired, my lord. I telephonically informed him, these are the excavators I repaired. One is beyond repairable. So kindly you give the money. So in the meantime, what happened, my lord, that in earlier time when this excavator were with some other this contractor, so he engaged there some caretaker or some driver or caretaker, all those things. So what happened when this excavator I took, so some problem started there. Some of the locals from there whom the respondent engaged as a caretaker to look after, so they started saying that this respondent did not pay them money. Therefore, they started saying that, giving disturbance to me, my lord, saying that thereafter they seized the excavator. Now I will show from the document, and how when it was seized, then how the Mariang police again after contacting him, how it was released, my lord. I will show here, my lord. Now, my lord, kindly turn to page number 31. My lord, page number 31 is the type copy, and page number 32 is the document, my lord, is the written copy. May I read, my lord? Who sees this document? ASIK Dasung IFP handed over 2 nodes of key of excavator of Manesh Agarwal to Karken Ngomdir, me, Charali Pasigat, with permitted by Manish Agarwal today, which was seized by me on in the complaint by Sri Karken Ngomdir. My lord, this some liability or some issues were there with him about this Karken Ngomdir. Then this was seized by the police, discussed with him, then it was again handed over to him with his permission, my lord. That is what exactly this document is saying, my lord, here in this, my lord. Then, my lord, then what happened, my lord? Very interesting. Then all these things happened. Then some disputes also arose between us, because first he misrepresented that all the machines were in good condition. Those were not in good condition. I incurred some live money. I asked for the repayment. He refused, because, my lord, at that point of time, I was interested to execute my project. I had to, but machines were not in proper condition. In addition to that, he was having some problems with other people also, my lord. Then what he did, my lord, he forged my letter pad. My letter pad he forged everything, and he prepared a forged agreement in the name of his mother. Now he is saying that no, petitioner went to the Dibrugarh met his mother in the office and made the agreement with the mother. And I have not met her mother till today. I have not seen my. And he forced that letter paid everything. Then why the reason, my lord, I will just show why he did forgery, all those things. He could not go to Arunachal to get those excavator. So he had to make somehow case in Assam, Dibrugarh. How to get the case registered, and with the help of police, how he gets his machine recovered. That shows his entire intention. And during his interrogation in 161, in my FIR, my lord, against him, he has all these things he has admitted in his 161 statement also before the police. Everything I did at the instruction of my counsel. So what he did is, my lord, false FIR, forgery, after making forgery documents showing that agreement was entered with his mother at Dibrugarh, then FIR was lodged at Dibrugarh police station. My lord, this FIR, my lord, will find at page number 28.
This was lodged by you.
My lord?
You lodged this FIR.
No, my lord, here I am saying respondent. Because he could not come to Arunachal to get that excavators. So somehow he wanted to file the case.
So this is the FIR of the present case.
Not present case, my lord. And
Another case.
things comes in that way, my lord. Now, my lord, he lodges this FIR. First, how he lodges this FIR? To make the, my lord, to confer a jurisdiction to the Dibrugarh police station, he manufactured a forged document, agreement, stating that I entered in agreement with his mother at Dibrugarh. And thereafter, I was declining to give those excavator, and with that one, this is the FIR, my lord. Niri demanded from us and declined the Mariang 310. My lord, may I read that FIR, my lord?
Yes.
Just read. Yes, my lord. I would like to bring you notice that Mr. Tagung Nari so and so had issued a work order at our office with my mother Bimla Devi Agarwal at above mentioned Dibrugarh address. My lord, itself is saying that how he wants to confer jurisdiction to the police. Copy attached for taking 4 hours of excavator on period of 4 months. After, my lord, this type copy. There is no type copy. After the completion of the agreement period, he neither paid any money charges nor did he hand over the said excavator. My lord. He's saying, my lord, he neither paid any money charges nor paid her by the said excavator. Basically, my lord, this is a civil matter, my lord, even if we say, but intention will see, my lord. Tagore abused and threatened us with dire consequences whenever he was approached with them to pay the agreed hire purchase return. I myself was physically assaulted in his scheme when I approached Mr. Taguneri to return the excavator. The said action and assault were brought to the notice of the K. Darang IC Mariang Yangkyong Upper Siang Arunachal Pradesh, who instead of taking action against Mr. Taguneri demanded from us and declined to lodge FIR. Mariang also threatened to so and so and so and so. From reliable source, I came to notice that the Tarun had excavated out of project site and sold them. After much search and follow, one of the excavator bearing so and so found jurisdiction of Sejosa. Another person working was said to have purchased the excavator. The said was seized and case was registered. So again, recently, some informed that another excavator has been misappropriated but sold by Tagung Neri to some and being transported on vehicles. So some police intercepted bearing so and so, so and so. That after 2 excavator bearings, it is still not. It is likely that Mr. Tagu has misappropriated them and sold them. It is important to mention that Mr. Tagu Tangri was supposed to return the excavator in perfect running condition. So and so, taking action in criminal and cheating, fraud, help, and so and so and so and so much. Now, my lord, entire this FIR, what he's saying, my lord, only otherwise, my lord, this everything cause of action, everything arose in Arunachal Pradesh. Excavator was there, everything was there. But reason may be there, my lord. He went there, is saying that itself police did not take the action. Therefore, he devised with the idea that, okay, confer the jurisdiction to Dibrugarh, then he manufactured this particular agreement, my lord. Now, my lord, very interesting. My lord, may I take to page number 27, my lord?
Yes.
My lord. Now, in the FIR, my lord, nowhere he has stated about making of my advance payment. Now, this is a certificate given by the Ashish Kumar Agarwal, whom I issued the check as directed by the Mr. Agarwal, the respondent herein. He directed that 14 lakhs advance amount has to be given. My lord, one question I asked myself. Now, he has just plainly said in the agreement that without giving any advance money, without taking from me money from me, will anybody give 4 nose of excavator? But in very interesting, my lord, in the this agreement, which is alleged to have been written with his mother, my lord, nowhere these things are mentioned. But in my lease agreement, it is very clear, my lord, 14 lakhs rupees advance is to be paid, my lord. Then this 14 lakhs advance, my lord, how this was paid, and this Ashish Agarwal, my lord, this certificate was issued, my lord, but he was summoned by the police on the basis of my FIR, because I also lodged FIR against Agarwal saying that he induced me, he misrepresented the fact about the ownership of the excavator, and he used the false document to create the false agreement and lodge the false case, man. Therefore, my lord, this is the certificate given by the Akash Agarwal. I will just read it about 14 lakhs, my lord. I, Ashish Kumar Agarwal, hereby declare that on request of Mr. Manish Kumar Agarwal, I had deposited check bearing number 2424 of Mr. No in my HDFC bank account, which was actually handed over to Mr. Manish Agarwal. The detail of which are follows: 14 lakhs. The following amount has been distributed from my account as per the instruction of Mr. Manish Kumar Agarwal. The detail of which are as followed: 1 lakhs Dungsam Cement Corporation Limited, 24/1 Bimal Agarwal, mother of Manish Kumar Agarwal, 3 lakhs, Jain Enterprise Dibrugarh 3 lakhs 75, Manish Kumar Agarwal 6 lakhs, total 45. I hear that all the information submitted and the true, and I have also attached a supporting document in the bank statement. So this person, to whom on his instruction, my lord, this check was given, he has, with bank record statement, he said that how he distributed all this money to at the instruction of Manish Kumar, and some of the money went to the account of the Manish Kumar Agarwal. Now, my lord, what he does, then he succeeded in getting FIR registered at Dibrugarh. Then, with the help of the police of the Dibrugarh, my lord, out of the 4 excavator, 1 excavator is still lying in the jungle, not in the condition since first day. 2 of the excavator he got seized through the help of the Dibrugarh police, my lord. He got it back. 1 of the excavator is lying in the Duimuk police station in connection with the case, my lord, where he also lodged against one complaint against one another person in the Sejusa, saying that that excavator was found working there. Now, my lord, thereafter what happened? How this case has a connection with this Dibrugarh case, my lord. Then, my lord, apprehending, my lord, arrest in Dibrugarh case, my lord, because basically this is a false case, my lord. Then I approached this honorable court by filing, my lord, anticipatory bail application. Then, my lord, in the anticipatory bail application, my lord, I used this rental lease agreement, saying that actually this is the agreement that was used and that was entered with Manish Agarwal, and I have never met his mother. No agreement ever been written with his mother, and I never visited Dibrugarh for this particular work. So with that help, then this honorable court, after finding that this matter seems to be a civil in nature, because ultimately if some payment is to be done, some payment is not to be done, my lord. Basically, this is a matter of civil nature. Then was pleased to grant me pre-arrest bail. Then, my lord, what happened? Then pre-arrest bail, and very interesting, my lord, this FIR, this was filed in the this Dibrugarh FIR, my lord, 2018. Police after investigation says that no case. Final report filed. Thereafter, he again filed the protest petition. And thereafter, as on today, my lord, so far best to my knowledge, my lord, no charge sheet has been submitted in Dibrugarh police case. Even after 2018, my lord, now almost after, my lord, more than almost 8 years, my lord. This case, no charge sheet. Final report was filed by the police, my lord. This is the stage of the case. Police could not find any incriminating materials against me during the investigation. They were satisfied that no agreement was ever executed between the mother of the Manesh Agarwal and me at Dibrugarh. No case has been filed. Madam, thereafter, I also filed one FIR against him in Dibrugarh, in Duimuk, my area, my lord, where I have said, my lord, that this after this agreement, that my lord will find at page number 52, my lord, my FIR. This on 28th April 2018. Immediately, my lord, on 20th, almost 20th April, he filed FIR against me on 3rd April. I filed FIR against him on 20th April 2000 itself, my lord. Where, my lord, I also allege him how, under what circumstances he made me to, my lord, induce me to go for the this dealing, and the neighbor denied of having done any agreement with the mother, all those things, my lord. My lord, may I take to, my lord, his 161 statement, my lord, and he was arrested in this case, my lord. May I take, my lord, to 161 statement of the accused person, my lord. My lord, kindly turn to page number 10, my lord. This will make things everything clear, my lord. Page 53, my lord. He was arrested in that case, my lord. Later on released on bail. And during investigation, it is his statement 161, my lord. May I read, my lord? On being examined, I am to state that I have 5 members of L&T Komatsu hydraulic excavator. This machine belongs to my mother, Sri Bimla Devi Agarwal, and I am looking after her machine. In the month of January 2016, I have been approached by MSJKM and KNRA joint venture company that they want excavator for hire basis. On their request, I agreed and given my machine to MSJKM KNR joint venture company. Accordingly, they have taken the machine after the agreement for the period of 1 year. After the expiry of the agreement, I have given 4 notes of excavator to Sri Tagung Niri on 21 2017 on hire basis at the rental charge of rupees 3,50,000 per month. I have never told him that the machines are actually belong to my mother. He has given me rupees 14 lakhs as in advance payment. Then after, I have never visited to the site of Tagung Niri to see the machine, although the Tagung Niri called me several times to visit at Mariang. I am Tagung Niri, my lord. Then after about 1 year, I have falsely lodged FIR against Tagung Niri at Dibrugarh police station, alleging him that he had physically assaulted me, and accordingly a case was registered at Dibrugarh police station. I have also submitted a document letter paid of Tagung Niri to Dibrugarh police station, citing falsely that the agreement made at Dibrugarh. I admit here that I have committed wrongs toward Tagung Niri. If I happen to meet him, I will beg pardon. Why have you lodged false FIR against Tagung Niri at Dibrugarh police station? It was done on the advice of my advocate to get back the Falkland from Tagung Niri without paying repairing charge. Because my lord, dispute came because I invested so much of money in repairing the machines, my lord, and he was not ready to pay that those fees of repairing, my lord. So this is how all basically the main bone contention of the entire issue is because of that one only, my lord. Because my lord, it is something that this excavator were already used for 1 year by other company, KNT and joint venture, and I was make the impression that all are in good condition. So I thought that it would, but during when I was using those machines, my lord, it was not in good condition. So, but I had to repair, and as per the agreement, he had to bear that repairing major repairing charges, my lord. And when I started asking him, he started refusing, my lord. So dispute arises, and apart from me, my lord, he was having dispute with others, and it was under these circumstances, my lord. In Dibrugarh, police case was filed. He managed to get back the machines, my lord. Now, my lord, to get this anticipatory bail, my lord, was issued by this honorable court by order dated, my lord, 6/10/2020. My lord will find at page number 33. Here, my lord will come at page number 34, my lord. This honorable court says, my lord, this is a civil case. Because, my lord, this is all about, my lord, admitted fact, my lord, either of my rental agreement or his rental agreement. Now the question is that I am denying the rental agreement. He is alleging that I entered with his mother, which I vehemently deny, my lord. And now he is also saying that he is denying that he ever entered any lease agreement with me, my lord. Now, this is the issue. Now, actually, my lord, facts is the case. This has arisen because of the commercial transaction, my lord. It was taken on lease. Either if I say that either by my lease of agreement or by his lease of agreement, what he is saying, my lord. It was taken on lease. Some liability was there, but my lord, he could not take it back. Criminal case was lost. My lord, I had to approach this honorable court, and I use that lease agreement. Now, later on, my lord, then my lord will find one more, my lord, page number 35, my lord. This is the order of the magistrate, my lord, Dibrugarh, my lord, this case, whereby it is said, my lord, that this order on 2019, it was passed 11/6 for further investigation, since police could not find any materials against me. And till then, my lord, no charge sheet has been filed, to the best of my knowledge, my lord. Subsequent, that part, I have no knowledge also, my lord. And my lord, case record of this particular police case has been called also, my lord, in this case. Now, thereafter, my lord, then what he does is, my lord, then he filed, my lord, this. First, he filed a FIR on 39/2019 before Latasil police station, alleging that the rental agreement I use in my anticipatory bail application is a forged agreement. My lord will kindly file 39/2019, the FIR of this particular present case, my lord. My lord will find at page number 57. 57, my lord.
Yes.
My lord. May I read, my lord? This is the FIR of the present case, my lord. FIR to the officer in charge, Latasil Police Station, Gauhati, Assam. FIR against Tagung Niri, so and so, Suspal Paso for criminal conspiracy, cheating, fraud, and criminal breach of trust. Anticipatory bail application, so and so. Please find attached herewith a copy of the anticipatory bail petition filed by Tagung Niri, so and so. On page number 21 and 20 of the incident petition, Tagung Niri has attached enclosed are allegedly signed by me. I would like to hear that no such agreement had ever been signed and executed by me with Tagung Niri for leasing out excavator. I would also like to hear that signature on page 12 have been Manish Kumar as lesser are not mine. The said signature is a forged so and so. Then he files this FIR, my lord, saying that I use the forged agreement, my lord. Then initially, my lord, this FIR was, my lord, refused. This police officer refused to register the case. He again approaches, my lord, commissioner, police, my lord. Page 71, my lord, will find. Commissioner police, he approaches. Then Commissioner Police, he endorses this application to Deputy Commissioner of Police. Then, my lord, Deputy Commissioner of Police, white order dated, my lord, will kindly turn at page number 77. Then Deputy Commissioner, it seems, my lord, Deputy Commissioner of Police, he, by order dated 4/10/2019, he directs the officer in charge, you register a case against him, the petitioner. Then, my lord, investigation carried out. Then, my lord, during the investigation, of course, my lord, in my petition, my lord, wrong statement inadvertently, I made a one statement there. I was not summoned for even once during the investigation. But later on, my lord, on the specific query of this honorable court, and that clarification was sought, my lord. Yes, my lord, for once only I was summoned in this case. I appeared, my lord, and since the offense is below 7 years, my lord, then I was immediately released on bail, my lord. Then, after my interrogation, my lord, that is that clarification I have done, my lord. Otherwise, my lord, that particular statement, of course, is not going to help me in my case in any way, my lord. This that was only the inadvertently that statement was made, my lord. But because my summoning, my visiting, appearing before the police or not appearing, my lord, merit of the case, it will not affect in any way, my lord. And there is no reason that I should make this statement deliberately false statement, because I'm not going to get any benefit by making such statement, my lord. Maybe, my lord, lack of communication, my lord, at that point of time, my lord. So, my lord, thereafter, my lord will find charge sheet, the impugned charge sheet. My lord, kindly turn to page number 80. Charge sheet was filed on, my lord, charge sheet number 480, my lord.
Yes.
Charge sheet number 14 of 2023, date 24 2023. My lord will find the operative portion, my lord, contains 81A, page number 81A. My lord, just small, these findings are there. I will just read it out, my lord. My lord has got
Page?
81A, capital A.
Okay.
My
Yes.
lord. I'll just read, my lord, brief facts of the case, my lord, in the left side column, my lord. The fact of the charge sheet is that on so and so, the complainant Manish Kumar lodged a complaint informing that one Tagungiri also had filed anticipatory bail petition in the Honorable Gauhati High Court so and so, and with the bail application, Sri Nagung Taru had submitted a forged equipment rental agreement purporting to be executed in between him and the complainant for hiring 4 numbers of Pockland excavator. During the investigation, the complainant Sri Manesh Agarwal and the witness had been examined in connection with the case, and their statement recorded under section 161. One photostat copy of equipment rental agreement, specimen handwriting and signature of Manish Agarwal. One photostat copy of application by Manish Agarwal addressed to SPL DJP so and so, and specimen handwriting and signature of Sri Taguniri had been sent to the DFS Assam Kahilipara Guwahati for examination and furnishing of the opinion. As per the examination report, the photostat copy of the application of Manish Agarwal addressed to the SPF and specimen handwriting and signature are same. But there is no opinion in respect of the question document. One photostat copy equipment so and so. So, my lord, the official report has failed to give any opinion regarding this particular equipment, my lord, rent agreement, my lord, which is alleged to have been forged, my lord. Now says, what's saying that, but during investigation, it is found that the question document, equipment rental agreement photo-state copy had been submitted before the Honorable High Court applying for pre-arrest bail application with Dibrugarh police case number under so and so. And on physical appearance, the signature, now my lord, on physical appearance only. Now the IO is saying that by seeing physical appearance, the signature of the Manish Agarwal put in the equipment rental agreement is far from the similarity with the specimen of signature of Manish Agarwal and the signature of Manish Agarwal put in the photo state copy by Manish addressed to the so and so and so. Under the circumstances, it is found that the accused Sri Tagung Miri had manufactured forged equipment rental agreement purporting to be made it mean between himself and the complainant Manish for hiring 4 numbers of police submitted on so and so at the time of applying pre-S therefore. Now, my lord, here I beg to make one submission. Now the IO is saying, my lord, there is no any other materials. Is saying that by seeing physically the signature. Now, my lord, if suppose if a person wants to force somebody's signature, what he will do, my lord? First, he will try to make it sure physically the signature should look similar. Man. It is not something somebody will make a forgery signature which cannot be have any similarity between both the signature. Man. So, my lord, the basis saying that just by physical showing, because a person can make it 2-3 signature, my lord. But only because that part, because one time a person will make one signature, second time in some other place he will make another signature, but that itself cannot say these two signature are different signature and forged signature, my lord. Now the conclusion, my lord, of the IO is only, my lord, that on physical appearance of the signature. So that is my case, my lord. Now, my lord, we'll see what's the place of occurrence is shown in the place of occurrence, my lord, will find page number 83.
No, but just hold on for the moment. I'm
My
trying
lord.
to understand.
My lord.
Let's stay on page 81A.
My lord, page.
Firstly, as per the FSL,
my lord, my lord.
what was given to FSL, one photostat copy of the rental agreement, specimen, handwriting and signature of Manish Agarwal, photostat copy of application by Manish Agarwal addressed to SPL DGP. That is a prior document, perhaps.
These are, my lord, these are the not the prior document, subsequent document, my lord, because after filing FIR, my lord, when his FIR was not registered, he addressed this to SPL DGP, L and so and specific handwriting signature of Manish Agarwal. After filing of FIR, my lord, maybe, my lord. It is
and
not
your
clear
specimen
also.
signature.
My lord.
And your specimen signature.
My lord, my specimen was also taken, my lord.
So what is the finding on your signature?
My lord, nothing, my lord. This is what is saying that, but there is no opinion in respect of the question document. Not even about my signature, my lord. My lord, the document in question, no findings, no opinion has been given. FSL.
Where is the FSL report? Is it there?
My lord, that when the charge sheet, that's why, my lord, the respondent was alleging me that I suppressed the FSL report ID, because when I obtained this charge sheet, my lord, I was not supplied with this FSL document. Even, my lord, this is not certified copy, but it was obtained through the advocate only, my lord. Then, my lord, this case records, my lord, case record is available with before my lord can go through those record, my lord, because I am also basing from this statement only, my lord. Now my lord, now allegation has been put against me that I suppressed this FSL report, my lord. This FSL report is in my favor, my lord, and it's saying nothing, nothing is given there, and this I have not seen as on today, my lord.
Is it annexed herein in this petition?
No, my lord, I have not received as on today, I have not seen FSL report, my lord.
May I, Lordship? It will be in the PRC case 878 before my Lordship. The records are here, PRC case 878, Lordship.
Wait. Report এখন আছে নাকি? এইটুক থাকবে। Yes, you can continue.
My lord. My lord.
See if there is an FSL report there.
My lord. My lord, this charge sheet copy, my lord, because it was procured through a council, my lord, based at Gauhati only, my lord. Then, my lord, but while giving this, my lord, no certified is given there, my lord. But most probably, my lord, there is no allegation that any this charge sheet I have manipulated or nothing, my lord. Most probably, this is the photo state copy of the charge sheet which is available before this honorable court only, my lord. So, my lord, this FSL report, my lord, this conclusion saying that nothing about my even signature, no opinion, nothing is there so far this agreement is concerned, my lord. Now, only basic saying that physical appearance, his signature, that subsequent signature, it doesn't resemble. That's why iOS says that prima facie case is made out against me. Therefore, this charge sheet has been filed. Now, my lord, one more pertinent question, my lord, I would like to bring on notice of this honorable court. My lord has seen that this entire charge sheet, my lord, there is no findings as well as where this forgery was done, when it was done. Well, there's nothing. But 83, my lord, page number, place of occurrence, my lord, is saying that it's inside the court campus. Page 83, my lord. This is a sketch map, my lord, of the place of offense. Now, my lord. Now, it's showing that it is inside the old building of our Honorable Gauhati High Court, my lord. This A, my lord, has seen my lord, page number 8.
Yes, PO.
My lord, PO. A. It's indicate the complex of old building of Gauhati High Court, where the PO as so and so, so and so. So place of this document was there. Now, my lord, why I am referring this part is important here, my lord, is that, my lord, ultimately the allegation against me basically is, my lord, I have knowingly manufactured this document with a view to get the pre-arrest bail from this honorable court. The allegation against me is that thereby I have affected the administration of justice. Now, if it is so, then 195 bar will automatically come. Now, he may argue there because law is saying that the custodial eagles, my lord. Because long back time, if document is forged, later on, if it is produced before this honorable court, and there is a gap in the time, then of course that 195 bar will not come, my lord. This has been clarified in subsequent judgment also, because document has to be in the custody of the court. And when that forgery is done, then only 195 bar will come. So I am today, my lord, harping this 195 bar, why it will come? Because here it is not something, my lord, this allegation is not something, this rental agreement I forged long time back for other purpose, no. Rather is showing that it was done within the High Court campus, Honorable High Court complex. This forge was done, and therefore, my lord, the allegation it seems that this is affecting the administrative justice. Now, then that bar under 195 will come, and that says that on the basis of the private complaint and police charge sheet, my lord, that cognizance could not have been taken, my lord. That is also one of the ground. That's why I am referring to this particular things, my lord, for that purpose, my lord. Now, my lord, Now, my lord, may I take my lord to impugn order, my lord, whereby the cognizance was taken, my lord, the page number 84, my lord. Let's go page number 84. My lord, this is the impugn order, my lord. 26/2023, my lord. Case record is received from learned CGM Kamru for disposal. Peruse the case record. On perusal of the case record, it appears that charge sheet was submitted against accused person termed with so and so alleging commission of so and so. Issue summons to the accused person. Prepare copies of relevant paper and document to be furnished to the accused. Fixing 29/8/2024 for appearance and report. And here, this cognizance, in which manner this cognizance has been taken, my lord. This is contrary to the, my lord, law, my lord. My lord has seen, my lord, this there is no exercise of any judicial mind, my lord. No reason given, my lord, that whether this is a fit case to call me to summon the accused person, my lord. And my lord, yes, my lord, this mechanically passed. Say that only charge sheet, he said that charge sheet has been filed, alleging, that's why issue summon is stated, which is contrary to the principle of law, my lord. Now, my lord, this is basically, my lord, these are the facts of the case, my lord. Now, my lord, what are the grounds, my lord? The grounds for, my lord, quashing this particular cognizance taking order. First, my lord, this cognizance has been taken in violation of section 195, 1B, so clause 2 of the CRPC, read with section 340. My lord must be aware about this provision, my lord, or may I require to read, or my lord not required, my lord?
What are you referring to?
My lord, this is cognizance has been taken in violation of section 195, 1 clause B, sub clause 2 of CRPC, my lord. Read with section 340, my lord, which says, my lord, when any such allegation is there about, my lord.
Yeah, let us go to 195 once to refresh my
195.
memories.
Yes, my lord, 195. 195 1. May I read, my lord?
Yes.
Prosecution for contempt of lawful authority of public servant for offense against public justice and offense relating to document giving in. No court shall take cognizance. Thereafter, my lord, I would like to take 1B, my lord. B, then subclause 2, my lord. No court shall take cognizance of any offense described in section 463 or punishable under section 471, section 475, or section 466 of the code when such offense is alleged to have been committed in respect of a document produced or given in evidence in a proceeding in any court. So there is a bar, my lord, because my contention, the petitioner contention is that though this document was not in the custody of the court, but the allegation is that their time gap is so short, and it is the alleged that this was manufactured within the court premises, my lord. Therefore, my lord, this bar will come because it is allegation something like that admission. So not necessary that every time it should be in the custody of the court, then only this bar will come, my lord. I will show that judgment regarding that clarification.
No, where are you saying all this from? What this provision that you have just quoted says
my lord.
Is alleged to have been committed in respect of a document produced or given in evidence
My lord.
in a proceeding in any court. Where is the question of manufacturing in the court? It only needs to be presenting it is sufficient
But
to attract 195.
subsequent judgment apex court has clarified this provision, my lord, and
Yes.
says, my lord, that only presenting is not enough. This document, anything, it should be in the custody of the court. Then this manufacture, everything, it has to be done when it is in the custody of the court. So this plea, I think,
If it is in the custody of the court, how can it be manufactured in the
my lord,
court?
this is very interesting. I think respondent will take this plea, my lord, and there is a judgment, my lord. I will produce that one, my lord. And my contention is that, my lord, even though it was not in the custody, not required, uh, because the ultimately allegation against me is that immediately you did only for this purpose. This part I will clarify, my lord, because this is basically the contention of the respondent. He will say that this document was not in the custody. But my lord has rightly put the question that when it is in custody, where the question of manufacturing? So that part is there, my lord. But this is how the law has been dealt by the Honorable Apex Court, my lord, in that aspect. But earlier law was not in that way. But subsequent there was so conflicting judgment, my lord, and this has been finally settled, my lord. So this is basically one ground. I will, my lord, place some judgment in that regard also, my lord. Then, my lord, second part, my lord, as I said, my lord, where is the material in the charge sheet, my lord? Can we put some person to face protracted criminal trial only of the IO, that physical appearance IO things, who is not even the expert? Because two signature for him, it doesn't resemble, my lord. I don't feel so. This charge sheet, even if we take in its face value, the principle for quashing, my lord, even if I take it, the entire materials in its face value as a gospel truth, can it be, my lord? Is it sufficient to convict? No, my lord. Some material has to be there, my lord, to make me to suffer. Moreover, my lord, I am a resident of Arunachal Pradesh, Itanagar, my lord. Once this criminal proceeding is allowed to proceed on this kind of, my lord, insufficient evidence, my lord, no evidence at all, I would say, my lord, with my humble submission, my lord, with respect, my lord. My lord, this will amount to abuse of the process of court. That's why, my lord, 482 is there, my lord. My lord is being clothed with that power to check this kind of process of law, my lord, where one should not suffer. Of course, I understand the scope, my lord. I'm not saying, my lord, to go into the disputed question of fact, all those things, that this is right, my lord. But what is there in the charge sheet? What is the materials there, my lord? Apart from that. So, this is another reason, my lord.
According to you, where was this agreement executed?
For me, my lord, Silapathar.
Between you and this and
Silapathar. Silapathar, Assam, my lord. And, my lord, I have never met his mother as on today, my lord. I'm saying it repeatedly, my lord. And very interesting, my lord. All these cases, we both are fighting, giving all these cases, but not a single time his mother has been examined by the police even, to find out whether really you entered with the this agreement with, or whether, I don't know whether his mother has ever seen me even or not, my lord. No exam, nothing, my lord. That's why, my lord, once this my case was filed, my lord, this the case which I filed against him, that was filed as again the police filed that as, my lord, final report. Again, I had to file the protest petition, saying that mother was never called, my lord, by the police, because the allegation is that that agreement which was used in Dibrugarh, whether that agreement was executed by his mother between us, that mother has to be called and examined, my lord. But my lord can see all this last 2018 till today, nowhere in the mother, from filing FIR to pursuing the matter, is the again the petitioner in person also. There's a question of even locus also, because he himself saying that this excavator doesn't belong to me, it belongs to my mother only. That question is also there. The victim, the purported victim, is his mother. He is not the victim. But last 9 years, he has filed me more than 5 cases.
Where is that other agreement with the mother that you were?
My lord, this part. Just
So according to you, that agreement is the actual agreement, the one executed between you and Manish Agarwal,
Yes, my
wherein
lord.
it is mentioned that 14 lakhs has been paid.
Right,
That
right,
is the
right.
genuine one.
Yes,
And the one that has been shown to have been executed with the mother, that is not a correct one.
not a correct one. That was only to confer the jurisdiction at the Dibrugarh police station, that he manufactured it. And 161 statement, he has, during his investigation, he has said also why I had to do.
So
And he,
your signature is purportedly there in that agreement.
that agreement is there, which I am blatantly refusing. And that's why, my
Lordship,
lord, Dibrugarh police also till today has not filed any charge sheet.
Lordship, page 121 of the IA will clarify everything, Lordship.
Okay, we'll come to that. Let's hear him
Lordship.
first. Yes, go on.
My lord, lease agreement certificate.
Lordship, state is the respondent number 1 in the criminal petition. May the public prosecutor add something before I make up my arguments, if they have
No,
something.
let him complete first. I don't think.
Okay, I apologize, Lordship. I thought he has completed.
My lord, my lord, here, my lord, I think I have not, I have not, I think, enclosed that agreement with the mother. I think it seems, my lord, in my petition, most probably. I think whether he has done it or I will check it. And my lord, when he will be submitting argument, my lord, I will check it, my lord, that part, my lord.
All right.
Categorically statement, my lord, never, my lord. Never. That's why, my lord, Dibrugarh police case, even after 8-9 years, no charge sheet could be filed against me, my lord. And they also know that was only done to get back the excavators. Purpose was fulfilled. That is that. That is the case. Now, my lord, other grounds, my lord. My lord,
First ground was regarding 195. Second is this no case is made out, even if it is taken to be true.
My lord,
Yes,
no
then
evidence,
thirdly?
nothing is there, my lord. Bhajanlal, all those judgment, my lord, abuse of the process, my lord. My lord, third ground, my lord, here, that cognizance, my lord, has seen that mechanically it has been issued, which is not according to the law, without using the judicious mind. That's why that cognizance is also bad, my lord. That cannot be taken, my lord. Then, my lord, my last submission, my lord, is that as on today, my lord, multiple cases have been filed against me by by the respondent. And my other ground also, my lord, he is not a victim, my lord. He is a stranger interfering, my lord. Or rather, he should have said, my lord, he entered with all the transaction, not putting his mother, which is the truth. But he is saying that all the machine belong to mother, but what he is doing here, the respondent.
ये जजमेंट होता है मिठू इसको तुम पकड़ो हम जो बोले थे तुम ना इसको पकड़ो
So that is one another
इसका time
ground, my lord. And my lord will see, my lord, what happened. My lord has seen that in Dibrugarh FIR, he said that I physically assaulted him. And he lodged FIR at Mariang police. My lord, this is on the record. Vengeance, we can understand. He could not do anything in Arunachal Pradesh, which is the fact. Let's assume this allegation against me that I assaulted him. Assuming, my lord, for the sake of without admitting that for commercial business, sometimes it happens, man. There was a dealings, which he is also not denying. Only the thing is that he is saying that agreement I entered with his mother, and which I say that I entered with him. Now, my lord, from the, my lord, sequence of events, my lord, and the conduct. Now, when the allegation is that I assaulted him in Arunachal Pradesh, Marian, he could not do anything there to me. Police also did not take any action, but this is the way in which he has proceeded. That is also not proper. He should have taken the remedy as per the law. He did not do anything in Arunachal Pradesh. He came back to Dibrugarh. Then it's out of vengeance to make me suffer. And this last 9 years, my lord, he has filed multiple FIRs against me, multiple criminal cases against me. First, he filed for cancellation of pre-arrest bail. This honorable court has rejected, dismissed. He again filed so many cases. He always comes, he always opposes my application. But all the cases I have been granted bail by this honorable court. From this, even from the honorable High Court Itanagar bench. And my lord will see, as on today, 4 cases against me he has lodged, my lord. Now, 4 cases. First, he has a Dibrugarh one, my lord. Mariang, SB crime, Latasil police station, this present case. Sejosa police station case, my lord. So, my lord, this case number also I can give here details, my lord. Sejosa police case number 9 of 2017. Registered Maring Dibrugarh police case number 442 2018. Latasil police case number 326 2019. Crime bench police case number 02 2003. As on today, 5 criminal cases against me. But I file only one criminal case and I am pursuing that one. My lord, I understand the vengeance. Maybe the petitioner might have misbehaved with him, maybe. So he has not forgiven, maybe. But we cannot allow someone to abuse the process of law also, my lord. And he is abusing the due process of law openly, my lord. That's why, my lord, when this allegation of mala fide comes, my lord, in 482, my lord may kindly take into consideration this charge sheet and the investigation in which it has been done more carefully, so that my lord can see whether behind the scene what is there actually, my lord, or whether to for the purpose of, my lord, legitimate cause or to wreak vengeance. And when the apex court is saying also, my lord, when the multiple of cases are come, then we need to look even beyond what is written in the FIR words, my lord. Because, my lord, sometimes what happens, whenever we want somebody to put in the criminal case, what we'll do first, my lord? We'll first make sure that FIR is written in a best manner, so that by reading FIR, so that it should disclose all the cases. We'll take the utmost care, my lord. So altogether, this is how, my lord, generally the case is, my lord. So these are the grounds, my lord. Now with this, my lord, I will submit some relevant citation. Then, my lord, I will let the respondent to argue his case, my lord. I'll just cite some cases, my lord. My lord, so far, my lord, Bhajan Lal, my lord, is fully aware. 1992, Supply 1, SCC 335, my lord. Bhajan Lal, State of Haryana, and others, Bhajan Lal, my lord. That's for quashing of FIR charge sheet, my lord, when there is abuse of the process of law, my lord. All those things, my lord.
Yes, yes.
Para 102, my lord. Relevant portion, my lord, 1, 2, 3, and 7, my lord. Then, my lord, 2023, my lord. 2023 8 SCC 734, my lord.
Yes.
This is, my lord, this is Iqbal. Yes, my lord. Iqbal alias Abel, my lord. This is in case of multiple FIRs, my lord. Para 9, 10, and 11, my lord. Eleven is the most relevant, my lord.
Have you stated about those FIRs in your petition?
Yes, my lord, my lord. I've given about the FIR against me lodging. I've stated everything. That is there. I have stated. Then, my lord, next is, my lord, 2025 SEC online, my lord. This is about, my lord, issuing summons, my lord, how the summons has to be issued, cognizance has to be taken, my lord.
This is the citation.
2025 SEC online
Oh, great.
263, my lord, page number, para 12, 13, and 14, my lord. Then, my lord, this Gauhati, our 1989 SEC online Gauhati, my lord. '34, my lord, page 34. 1989 SC online Gauhati, page 34, my lord. Para 6, 7, 6 and 7, my lord. Basically, this judgment is for, my lord, because the respondent would say someone cannot be order taking cognizance cannot be challenged in by way of in 482, or someone cannot be challenged. But these judgments and other judgment I will, my lord, place, which says, my lord, this someone is not being not an interlocutory order, my lord. It is between the interlocutory and the final order, my lord. Then 482 application lies for challenging the such summon and cognizance, my lord. That is very clear, my lord. So this judgment also deal, because most likely respondent will take that objection, my lord. That's why he's saying that not maintainable, my lord. Then page, my lord, for this particular aspect, my lord, this 2025 SEC online, my lord. My lord, 2025 SCC online 263.
That you have already given. Yes.
My lord, my lord. Then, my lord, 2012 9 SCC 460.
Yes.
My lord, this is for pertaining, my lord, that's issuing summons can be challenged, my lord. It is not an interlocutory order, my lord. It's a maintainable petition, my lord. Then, my lord, yes, my lord. Para, my lord, para 2022, 2012. Paragraph, my lord, will find page 2, para 2, 15, 16, 20, 21, 22, and 23, my lord. Then, my lord, 2024, 11 SCC, my lord, page 733. This is, my lord, for in the absence of official report, my lord, the Honorable Apex Court quashed the entire criminal proceeding. And in this particular case, even, my lord, there was a official report from the private laboratory. The Apex Court says that from private laboratory, this official report cannot be accepted. And since there is no official report regarding this forgery, so entirely this case was quashed, my lord. In that context, my lord, I am relying this judgment, my lord. My lord will find it page number 32, 33, and 42. 32, 33, and 42. For that purpose only, my lord. And, my lord, 2025 SEC online, my lord. 208. This is for, my lord, mechanically issuing of someone, not permissible. Para 6, 8, and 9, my lord, and 10. Entire case was cost because from the impugn order, my lord, nothing could be discerned, my lord, that any exercise was done, my lord. Then, my lord, 2021. Then 2021 5 SCC, my lord, 435. 2021 5 SCC 435, my lord. Page para 18, 21, 22, and 23, my lord. This is also for the summon, my lord. Then, my lord, may I take to this two more judgment for
Last one was 2026.
2026, my lord. I will come. First is 2021 5 SCC 435, my lord. 2021 5 SCC 435, my lord. Para 18, 21, 22, and 23.
This is the name?
Case name is, my lord, Krishna Lal Chawla and others versus State of Uttar Pradesh.
It's not before me.
Okay, my lord. My lord, otherwise this is covered, only issuing someone. Then, my lord, I like to, my lord,
Just
about
give the
190
citation. Give the citation.
citation, my lord. Yes, my lord. Citation, my lord, will find page number 2021 5 SCC 435.
Party name is?
Party name is, my lord, Krishna Lal Chawla and others versus State of Uttar Pradesh and another.
Yes.
Then, my lord, this two more judgment is for, my lord, regarding 195, my lord. First, my lord, 1998 to SCC 493, my lord. 1998 to SCC 493. Sachida Nan Singh and others, my lord.
Yes.
Paragraph 7, 8, 9, 10, 11, 12, and 13, my lord. This has DLs, my lord, and specifically it says that because there was this judgment has deal with the aspect, my lord, especially paragraph 12 says, my lord, when it says, if I read paragraph 12, my lord, if it is says that within the precinct of the court and there was no such long delay in its production, then this bar will be there. So, my lord, this particular judgment, again, my lord, later on, my lord, 2005 constitutional bench judgment, 2005 for SCC 370, my lord. Then, my lord, 2005 for SCC 370, paragraph 2 and 33.
Pardon, I was on the earlier one, 1998. Now, next.
Next, 2005
Yes.
for SCC 370, paragraph, my lord, 2 and 33. Well, this is a constitutional based judgment. What happened, my lord? There was a conflicting judgment on the point that when this bar will come. So there was a conflicting judgment between this Sachida Nan Singh and other judgment. Then constitutional bench has resolved this issue, saying that what has been decided in Sachida Nan Singh is the right law. So therefore, my lord, relying Sachida Nan Singh case, now we cannot say that all the cases until it is in the custody or that forgery is done during the custody, that will not be there. There will be certain situation where it's saying that it is within the court complex or there is a production before the court. There is no such long delay. Then, my lord, my humble understanding of reading of this judgment that this is a case where it amounts to affecting the administration of justice. Therefore, bar will be there, my lord. But respondent would argue, no, this was a document, it was not in the custody of the court as per the dicta of Iqbal Singh Marwa case. Most probably that will be the argument, my lord. But reading of entire these two judgment, Sachidanand Singh and these two judgment, because Sachidanand Singh has been upheld. So if I read Sachidanand Singh, it says that though not necessary every time it should be in the custody of the court, time gap is also important. Then all earlier cases have been referred. My lord, last judgment, my lord, 2026 SCC online SC 1367, para, my lord, 11, 12, 15, 16, and 17. Why I am relying this judgment is basically I have been alleged, my lord, as I have submitted candidly, my lord, that while filing criminal petition, my lord, some wrong statement was made, saying that I was someone once, I was not summoned by the police. So later on, my lord, when the respondent raised the objection, this honorable court has asked me to clarify by way of affidavit. I have clarified by way of affidavit. I was asked also how this charge sheet was obtained. I have given elaborate the names of the advocate, local advocate also, through whom it was obtained, my lord. And about this rental agreement, where is the original, my lord? And that has been clarified, my lord. This is in the custody of the respondent, my lord. Now, another part, my lord, allegation was made against me that I received the summon from the trial court. No, my lord. I did not receive any summon from the trial court, my lord. Later on my inquiry myself only, during filing of the while pursuing, my lord, this my anticipatory bail application, he filed application for rejection of my pre-arrest bail application. While pursuing that matter, I came to know about this Latasil police case, and since I also inquired because I was summoned once by the police, so I also inquired about this status of the case. Then I came to know about all this case. So why I am giving this judgment, my lord? There is a difference between, my lord, every wrong statement cannot be said to be a false statement. False statement is something, my lord, when somebody makes deliberately by misleading to get some benefit from this honorable court, my lord. No, not at all, my lord. Otherwise, I would not have clarified in my affidavit very clearly, my lord. No, nothing, my lord. And those statements, my lord, I am not going to get any benefit also, my lord, because my merit of the case doesn't touch those aspect, my lord. I'm not getting any benefit, my lord. Now, my case is solely on those grounds, and these are the, my lord, my humble submission before this honorable court. So, my lord, with this, I conclude my agreement saying, my lord, this is the abuse of the process of court. Now I don't know how many more cases he will file against the petitioner. So with that, my lord, I will respond. I reserve my right to respond to the respondent with this much obligement.
Yes, anything to submit?
I have gone through the, my lord, trial court record, my lord. My lord, regarding this questionment of this, my lord, petition, my lord, that is related to, my lord, that is the PRC case number 878 2023, my lord, in respect of Lotasil PS case number 326 2019. That is FIR is lodged on, my lord, 10/10/2019, my lord. I have, my lord, flag marked, my lord, that is the, my lord, charge sheet part, my lord. Charge sheet was, my lord, submitted on 24/2023, my lord, against the accused petitioner, my lord. Police, during the course of investigation, they have, my lord, examined 6 numbers of, my lord, PWs, my lord. And, my lord, there, my lord, as per the charge sheet, my lord, PW 5 is, my lord, Rakesh, my lord, Sharma, who is the, my lord, scientific officer, my lord. He is the, my lord, scientific officer, my lord, from the, my lord, FSL, my lord, director of, my lord, forensic, my lord. And my lord, that regarding, my lord, as because, my lord, regarding, my lord, that is the document, my lord. Only the question is here only, my lord, regarding the placing of a, my lord, document and the signature, my lord. There, my lord, FSL, my lord, report is available here, my lord. That is also I have, my lord, trademark, my lord. Here, my lord, in the, my lord, search sheet, my lord, if, my lord, produce the search sheet, my lord, that is the last part of the search sheet, my lord, they have, my lord, stated, my lord, during the course of investigation, when they taken the, my lord, that is the, my lord, report, my lord. As because it is now, my lord, this case is, my lord, related to purely on that, my lord, part. Whether, my lord, this, my lord, whether is the document produced before the honorable court is the means of, my lord, fraudulent or not, my lord. My lord, where, my lord, it is stated that, my lord, they, during the, my lord, they clearly stated, my lord, signatures are same, but regarding, my lord, that part, as because that is a, my lord, Xerox, my lord, part, they are not able to make this opinion, my lord. So, but my limited understanding is that whether, my lord, that particular document is available or not, my lord, or whether, my lord, this, my lord, signature is, my lord, right or wrong, this, my lord, come only in the, my lord, trial only, my lord. Because, my lord, FSL is there, my lord, the document is there, report is there, my lord. So that is my understanding. And regarding, my lord, in the search sheet, my lord may peruse, my lord, para 14 that they have collected, that part is, my lord, they mentioned. My respectful submission.
official report says
Fine.
that the person who wrote the blue enclosed writings and signatures
My lord.
stamped and marked as S1 and S2, that means specimen,
Yes, ma'am.
specimen
Specimen,
signatures. Also wrote the red enclosed writings and signatures, similarly stamped and marked as Q4 to Q7.
My lord.
So Q3, no opinion. Q3 is the signature of Anish Agarwal.
Yes.
It's actually a scan copy, so not very visible.
My lord, in the my lord charge sheet, my lord, when they wrote about the entire investigation, my lord, that part also, my lord, let me read. Horizontal flag mark.
Q7. Sum and substance is that there is no official opinion with regard to this signatures on the agreement in question. This is with regard only to the specimen signature.
That is also, my lord, because
and the letter sent.
That was as because, my lord, that was a Xerox, my lord. Submitted. My lord, in the
So net
yes,
result is as of
yes,
there is no opinion.
Yes.
I ought to have collected the original.
Yes, my lord, because my lord, yes, my lord, that is during the course, him might, my lord, procure the same from the, my lord, that is the accused petitioner, my lord. Finally,
Whether the accused or the complainant, I should have investigated and brought the original.
My lords may kindly come to page 22 of the charge sheet, lordship.
Page 22 of the charge sheet. Page 22.
Lordship.
Yes, what is there?
Yeah.
Is there any
Lordship, I
pagination
find
in
from
charge
the annex. Lordship.
Any pagination in the charge sheet? I don't see any pagination. Oh, this is the that photocopy earlier given. Yes. You will see from the record.
It is a statement of the witness to this forged agreement, lordship.
Don't find any pagination in the charge sheet. Which part of the charge sheet you were referring to? Paragraph serial number?
Lordship, it's a statement of Lordship. I don't have the charge sheet with me. I'm relying from the annexures in this criminal petition, Lordship. On
Yes.
page 81A, paragraph
81A.
point number 2, Lordship.
81A. Yes, 81A. Right.
Page 81, Lordship, of the criminal petition.
Yes.
Lordship, 81 only, not 81. 81 point number 2, Lordship.
Yes.
Sri Suspal Paswan, page 22, oral statement. Lordship may kindly peruse this statement of the witness to that forged agreement in the charge sheet submitted before this court.
Been marked.
Learned PP may kindly peruse the statement of Sri Suspal Paswan on page 22 of the charge sheet.
Is it with you?
Lordship, it's not with me.
The case diary part is not available, my lord. Only the my lord charge sheet and those my lord FSL reports, those are only available, my lord. And where are you referring to it? Is it within your knowledge what is there?
Lordship, the petitioner in the criminal petition has used this forged document twice in the Gauhati principal bench and twice in the Itanagar bench. As I lodged a case here in Latasil, I lodged a case in Doimuk for use of fraudulent documents. The petitioner of this criminal petition has been charge sheeted for fraud and forgery in Itanagar bench also. And in that particular investigation, this Suspal Paswan, the witness of this forged agreement, has stated that I was not a witness to this. I was made to sign this agreement later on. I just wanted to show up that statement to my lords. If that statement is relied upon, two frauds further has been played on this court. Firstly, when he says the agreement is with the respondent, it is not so, it's with him. Because the witness to this agreement is stating that it was signed by me much later at the behest of the petitioner. And the trial court has taken cognizance for fraud in Itanagar bench also, Lordship. He has been summoned, he has suppressed it.
And clubbed it with this case. We want to see the records of this case, whether there is.
Since the documents are similar, the persons are similar, hence I did not submit. I just requested this court to look at the statement of Mr. Suspal Paswan on page 22.
Two statement on 20.
It appears it's not available.
161 statements are not available, my lord. Only FSL report and my lord, the search sheet is available, my lord. And my lord, we have to call for my lord, those my lord statement, my lord, because entire sheet
Lordship,
is not available.
it is a very painful situation. We received the trial court records after 18 months. A court which is just 5 minutes from this high court. And after 18 months, we don't have the proper documents. Lordship should take note of it, that it's hindering in the administration of justice. The office notice there, it was received after 18 months from Kamrup Metro, Lordship. And that to an incomplete set. Let me take my arguments further with the kind.
Yes, go on.
Lordship, there is an agreement. Lordship, before I part, I will seek my court's leave. Lordship, I need to reply to what the petitioner has submitted in the criminal petition. Second phase of my argument is the challenge to the maintainability. And third part is my IA, wherein I have gone ahead seeking some reliefs which can be taken up only at the fag end of the matter is taken up. Lordship, the argument of the counsel is that no judicial mind was applied while taking cognizance of the crime committed. If my lord pursues the order passed in Pramila Devi versus State of Jharkhand, it is made very clear that the magistrate cannot be dictated to write each and every word that the respondent or the accused wishes him to write. It can be a short order. Absolutely clear in the judgment of Pramila Devi versus State of Jharkhand. Lordship, he has stated that FSL is negative. That is a wrong and false statement. FSL is neutral. FSL says I can opine only when the original document is brought in front of me, otherwise not. Where has the FSL stated that this is not as per what he has contended in his complaint? Did the FSL say that it is my signature? A stalwart like him should know the difference between a negative and a neutral and a positive.
My lord, objection, personal attack he is making
I
again.
have got nothing against you. I don't consider you fit to be heard
it's
again.
because of
You
his
have stated right
my
and
lord,
now
because of
that
his
the
personal
FSL is
attack only
negative. How
matter
can you
was
back out from your statement?
last time also, my lord, the honorable judge had to recuse from the case because of his continuing personal attack to the
Absolutely false
advocate.
statement. The judge did not record anything such in the order. I have absolute objection to what he is submitting every time.
I request Mr.
You are
Manish
not
Agarwal,
requested here.
Don't,
I am
this is,
addressing the court.
I am advocate.
You may be anybody, but I am
Don't
addressing
make
the court.
personal attack.
I am
My
not
lord,
before you.
well,
Mr.
kindly refrain.
Respondent, you are not helping your case.
Lordship, each and every time he says the matter was recused because of my behavior. Where is the order?
He's responding to you. Why should you attack him? That my stalwart should know or whatever. Forget about him. You talk about yourself, your case.
Lordship,
you reply,
we have
reply
been
to the
quite-
points he has made.
Lordship,
you don't have
in
to
that
make snide
event,
remarks.
Lordship,
Yes.
in that event, I seek a next date because today we are already 2 hours into the case and the statements are also not there in the case diary. Let the records be called for properly and we can fix a date thereafter, Lordship. The facts of the case.
Right, we'll then call for the case diary part.
My lord, case diary part, my lord. 161 statements, my lord. Both my lord, my learned senior colleague also gone through. We didn't get, my lord. Not available.
My lord, this matter, my lord, since 2024, I have been pursuing matter. And my lord, since now I am no more protected, my lord. So, my lord, if trial proceeds against me, my lord, then this will become infractious also. This is I am worried about, my lord. And only my lord,
Lordship, next date is in the month of October. We can fix any date before that. 29th of October is the next date. We can fix it on 26th of October.
first September.
No, it's not 1st September. That is a wrong statement.
No. Let this case be fixed on 1st September. I am saying.
It's not your prerogative, sir.
I'm praying, my lord, that then if next date is given, my lord, then 1st September.
I am not at all easy with 1st September. Let the trial court records come up, then it can be fixed. It
We
makes
have to
no
fix
sense.
a date for the
fixing.
case. What are you talking about?
Lordship,
We
it
are,
took
when
18
we are
months for
calling
the
for the
records to
trial
come
court
up.
records, we have to fix a date.
Lordship,
Yes. So on that date, why can't you continue the argument once the records are here?
if the records are there,
Yes. If it's not there, it will be adjourned. Or you want to fix a date only for the records?
Lordship can fix anything to my Lord's pleasure. I have nothing against it. But the fact I brought, it took 18 months. I don't expect it to come so early.
Okay, I think we have heard you enough. Yes, we'll pass the orders. We'll fix a
Lordship.
date as we
Lordship.
want. Yes.
My lord, I may be accommodate, my lord, for the next date, my lord. So, I may, if I may have to travel also to Gauhati Center. Because, my lord, I am not protected, my lord. I am worried about that one only.
I think 1st of September is a holiday.
My lord, then, my lord, can it be on, my lord, 30 September, my lord?
Better do one thing. Yeah. Call for the record, only for the record for a short date, and then we'll fix a date for hearing.
My lord, if my lord,
Because for that only, whether the record has come or not, you don't have to travel all the way here.
my
Lordship.
So that let the records come, then we'll fix a date as per your convenience for hearing.
Lordship.
my lord, some protection, my lord.
No, your date is far away. It's not
My-
necessary.
my-
We'll fix it much before that.
My
But
lord,
this is
before-
only come just across
And
the
otherwise,
street.
my lord, I have made my submission, my lord, has already given
Yes,
enough
yes,
time of this.
We have recorded all your submissions, so you need not repeat anything.
Yes, yes.
We'll only wait for the reply. That's
Right.
all. We have also heard the state, so we'll reflect it. Steno is not here right now, so pass the order later on. Okay.
Deeply obliged.
For order, you can fix a date after 2 weeks, just after 2 weeks, because I'll not be available for the next 2 weeks. So,
My lords can kindly keep it part heard, Lordship.
yes, of course, it is part heard. What do you expect after all this time? Yes.
Lordship.
Deeply obliged. Deeply obliged.
For hearing item 47. Lordship, in this case, learned senior counsel, due to his personal difficulty, Lordship, leave the court maybe on the 18th, Lordship.
18.
Lordship. The part heard matter, Lordship.
Prayer of learned. 18th, this is part heard.
Lordship.
I'll not be available. Has to go to September.
Lordship.
8 September.
All right.
Anayak. Anayak. One is present.
The 15 matter. Some payment is going on. The last date also nobody appeared. Keep it pending. Yes, Mr. Alam had appeared. On. Like a short date DDO যদি appear no করে will this 2015 matter will not keep it pending forever. Next, give a date next week. Yes.
Chief, this is a 482 application. There are two at the very initial stage. Lordship, in the case, there are two private respondents, Lordship. The notice is deemed to be served. They are not. They never came before the court. The petitioner, Lordship, is a retired man now. He's around 72 years old. At the time of this alleged incident, Lordship, he was posted as an assistant engineer in Dhokua in Lakhimpur district. It is a very, very backward district with backward place, Dhokua which doesn't have any banks or any post office of that kind in that area. So there are the contractors who have filed this complaint case, Lordship, and the honorable court below, my main case is without taking the sanction of the government, the cognizance was taken into this case. Lordship, what happened? I just like to go to the background of the case. The complainants were I did not put it here, but I just mentioned about PL also. So shall I bring it before?
May I interrupt, my lord? In this case, my lord, our petition copy is missing, my lord. Available, my lord. Learned friends furnish one copy, my lord. Secondly, my lord, the respondent have not appeared, my lord. There are two respondents. Some amicus may be appointed to assist this court. The quashing petition, my lord.
No, because it is several occasions we served notices. They received it.
Not with it.
No, they said received, but they did not accept it. It is in. I have made a sheet of it. I have with me all the dates. Yeah, this is the sheet. On 19/12/2016, Lordship, the first notice was served. 26/3/18 refused to accept, but AD was returned. It's the mark was there. It's on in the file. Lordship will peruse the orders. 26/3/18. The notice deemed to be served on signature was there in the AD. 16/5/2018. Again, before that, again, we took steps for respondent number 2, unserved with postal remark, adhered, refused. For 3, signature of one Kamaikya was there. So again, we took steps for the third time, Lordship. And on 11/1/2021, one lady, some Chiang Mai had accepted the notices on behalf of 2 and 3, and that 11/1/21 it says it's deemed to be served, and she's the wife of respondent number 3 and the sister-in-law of 2. May I repeat the dates?
What is the point of hearing if you, it is to be adjourned again?
I have also, my lord, not aware, my lord, whether it was available or, but I have find search, my lord, it is not available, my lord. Anytime, my lord, next week, my lord, let my learned friends have
Alright.
furnish a copy.
Third learned counsel for the petitioner, learned edition. Is that the copy of the petition not available on file? You submit a copy.
You mean I'll be submitting it just now, I have it.
Counsel for the petitioner. Submit a copy of the same. Furnish a copy of the same to learned edition LPP. Is the matter again on? Yes, give a date.
8 September, Lordship.
Oh.
Lordship, I would like to point out, on the last occasion when this matter came out, I was out of station. And on that day, on that particular day, this matter was fixed in the monthly list. And I also informed the bench that I'll not be there. So it also came out in the daily list, and it is shown I was absent, and immediately one amicus have been appointed. The amicus may be struck out, Lordship. The name of
Continue,
my-
yes,
I have spoken to her. My client also spoke to her not to appear before for him.
since, yes. Yes, Ahmed.
As Parveen.
Yes, Parveen, who is counsel for the petitioner, appeared. Here appointed is discharged. Discovery may be dated from the cause list. Next date of listing.
Of life.
Little lengthy matter now.
I'm not getting you. Speak up,
It's
please.
little lengthy matter. It might not possible today.
It is submitted by learned counsel for the petitioner that the FSL requires some time to be heard fully, and due to paucity of time, it may not be possible to get the matter today, hence the matter again on
10th September.
If it is 8th or 24th September. 24 is preferable. Oblige. Oblige.
Yes, your lordship. My lord, this is regarding, my lord, maintenance, my lord. Challenging the judgment of passed by the learned CJM in the main petition under section 125, fixing 14,000. For mother, it is 9,000, and for child, it is, my lord, daughter, it was 5,000, my lord. So total 14,000, my lord. Thereafter, my lord, the husband, my lord, preferred revision before the session court, saying that, my lord, in the main case also, original case also, the husband wanted to disown the wife and the child, which is negated, my lord. Thereafter, my lord, in the revision petition, the same prayer was there to negate to disown the wife and the daughter, my lord. This is the dismissed, my lord. But 14,000 was reduced to 12,000. Thereafter, my lord, on the other hand, my lord, the husband has filed a title suit, my lord, to disown saying that the marriage is void, not legally permissible, my lord. Thereafter, it is dismissed with cost. Then title appeal filed, dismissed with cost. Then, my lord, second appeal filed, dismissed with cost, my lord. My lord, in total, my lord, there are around 30 or 32 cases, my lord, that he has filed, including bail petition and all this, my lord. And what happened, my lord, in the process, my lord, I have to sell all the paternal properties, my lord, to run the cases, my lord. And he said that it is in the document, whatever I am saying is, it is already, my statement is there and document is there, my lord. My lord, and he even said in the court, my lord, the statement is there, my lord, that till you go to Supreme Court, I will not pay a single penny. You will be bound to commit suicide, both child and the mother, my lord. That statement is there, I can show your lordship. My lord, then what happened, my lord? He again came to before his honorable court by filing my criminal petition under 235, that is on last day, my lord, is withdrawn it, my lord. And immediately got stay on the orders of lower courts, my lord. Entire year 2021 at the corona time. Thereafter, he said that he will not pay any rupee in spite of distress warrant, interim first order by the trial court, then distress warrant by the court, then warrant by lord court, then by the order by the session court to pay the interim, then finally to pay none, even not paid, my lord. Thereafter, when he came to High Court, then I prayed for just some amount of payment, my lord. Then he paid, till date he paid 6,10,000 perhaps in total. My lord,
Court direct, not court said.
courts by courts order, my
It's
lord.
not the pair of the respondent, but it was the court's
Yes, my lord.
proposal to depose.
Then, my lord, kindly see, my lord.
Just
It just let me just complete, my lord.
Now, what did you want to say?
Last occasion, my lord, we have raised one objection regarding the maintainability of the application. As regards the petitioner has seeking enhancement. So we raised an objection that under section 127, it is there is a provision, my lord, for to approach the trial court, my lord, where these grounds can be raised, my lord. And secondly, my lord, if lordship perigee page 19, the petitioner has challenged, my lord, two orders in this application under section 482. The orders passed by the CGM in the year 2018, my lord, and as well as the order passed by the learned sessions judge in revision. So there is also, my lord, my responsible submission that is also, my lord, a challenge, ground for challenge, my lord, of maintainability, that since, my lord, CGM order was not challenged, it under 482 it cannot be, my lord, at this stage it cannot be challenged, my lord, because 397 is there, my lord. The provision for revision is there, my lord. Apart from, my lord, 127, 397 is also there, my lord.
And this is the first revision by them.
Firstly, it was passed by the CGM in the year 2018.
So they filed revision against that?
No, madam.
No, husband filed.
Husband filed.
You filed?
Yes, madam. And it was reduced, my lord. The learned session judge has reduced it to 12,000. Then after we filed a criminal petition, my lord. That was on last occasion, my lord, withdrawn as change of. We have also prayed that there is change of circumstances. We'll go by section 127, and that liberty was also given.
This revision is against this session judge's order of 7,000 and 5,000.
As well as, my lord, sessions plus CGM, my lord.
Yes.
Lordship kindly peruse page 19. There is there, my lord, that both to set aside the both orders, my lord. On last occasion, it, my lord, skip my notice, my lord. Now I found that is specifically mentioned. Prayer has been made. I just read, my lord, this. Prayed this honorable court may be kindly pleased to enough to admit this petition so-called notice to the respondent as why the impugned judgment and order dated 19/2/2000 passed by learned session judge Karimganj in criminal revision number 27 of 18, as well as judgment and order passed by learned chief judicial magistrate Karimganj passed in list case number 228/2026 under section 125 CRPC dated 7/18 shall not be set aside. And as to why the amount of maintenance of the petitioner of shall not be enhanced, my lord. So both are, my lord, in my understanding, my lord, part by section 127 as well as 397 also, my lord.
My lord, I am going to legal point thereafter. My lord, kindly turn to page 77, my lord.
Now, from that judgment of 21, 5 years have gone by. You can now file 127 application for enhancement also.
But 127, your lordship is correct, but 127 only change of circumstance. Suppose, my lord, wife has got some job to be lessened, husband has got some lesser income or more income to be enhanced or lessened. My lord, I am challenging the amount itself, my lord. Kindly, my lord, I will go to the legal point next, my lord. Kindly turn to the page 77, my lord. 77, 78, and 79, my lord. Thereafter, 3 or 4 another cases, my lord, came pending in this honorable court itself, my lord, Gauhati High Court, my lord, against me, my lord. Such is the situation. Kindly, the list of cases, kindly see. I have penniless maid. I am just less than beggar. I am maid, my lord. And even the till date, my lord, not a single penny is paid voluntarily to his own child, my lord, daughter who is now reading class 6, perhaps, my lord. And I am, my lord, kindly turn to my lord page, my lord, the 80. Kindly see the situation, my lord, page 86, my lord. '86, my lord, the medical documents, my lord, the relevant important part is, my lord, at page, my lord.
I think others can go. This will consume sufficient time, I think. We're already past 4.
My lord, whatever, my lord, this is coming for hearing. And since, my lord, 8/1/2024, my lord.
That is why we are taking up.
Yes, my lord. For the one reason or other, it could not be taken, my lord, finalized, my lord. For one reason or the other, it could not be ultimately finalized, my lord. And thing is that, my lord, she is badly in need of money, my lord. The child is reading in class 6, perhaps now, my lord, and see the medical condition, my lord. She
All
needs.
right, all that is fine, but we are concerned with the legality of the order now, that you are challenging.
My lord, so, my lord, then a date may be fixed, my lord, if your lordship so wants, my lord.
And why have you come today? What for?
So, no, my lord, your lordship it will take time. That's why I thought that your lordship is my lord, inclined to fix, my lord.
And my lord, based, just if I may add,
lord,
lordship permits, that reference to page 86, my learned petitioner has.
No, we don't want to waste time hearing without any purpose. Either we are hearing the matter or other we are fixing a date. What do you want?
My lord, I want to finalize one, my lord. If your lordship, my lord.
Yes, we are hearing you.
My lord, then, my lord, kindly turn to page, my lord. Page 88, my lord. This is only to, my lord, to brief your lordship, my lord, to my lord, submit your lordship on behalf matter of, my lord. She has developed some cyst in the uterus and she needs operation from long. They have paid the amount for 1,50,000 that time. She could not go, my lord. She has taken loan from bank by giving, my lord, her ornaments and personal loan.
Revision, you have to show where this is not a mercy jurisdiction. You have to show where the learned session judge has gone wrong.
My lord,
My lord, all these grounds were earlier taken up by this court, and payment was also made because of these, my lord, operations and other things, medical emergency, my lord. And these are on records, my lord.
My lord, in spite of all orders, my lord, neither the trial court nor the revisional court could, my lord, have a amount of, my lord, his income, my lord. Even in the salary statement also he did not give, my lord. And one more thing, my lord, kindly turn the orders, my lord, in this matter, my lord. Kindly see the orders dated, my lord, my lord, order dated 21/3/24, my lord. Kindly have a look, my lord. 21/3/24, my lord.
Page?
Page, not page, my lord. This is order sheet, my lord. Of this, my lord. Order dated 21/3/2024, my lord. Order sheet. Order. It case.
Yes.
My lord, kindly, the respondent husband was directed to submit an affidavit saying, stating his, my lord, assets and liabilities as per Annex 1 of this very judgment, my lord. This is not been done, my lord, till date. And number 1, my lord. Then, my lord, kindly come to another order, my lord. Dated 28/8/2025, my lord. My lord, sorry. sorry, my lord, order dated 8/1/24, my lord, what I have shown, my lord, along with statement of, yes, my lord. 8/1/24, my lord.
Yes.
There is an order, my lord, specifically saying that to submit the statement of accounts of his bank accounts, my lord. He has many bank accounts, including, my lord, he has policies of LIC, nothing is submitted, my lord. Even violated these two orders also, my lord. Till date, nothing is filed, my lord. Very difficult for your lordship to ascertain the amount. And of course, my lord, the Supreme Court in this matter very strictly, my lord, laid down the my lord, principles that if he suppresses, my lord, there are measures, my lord, that
That
may be taken
affidavit
by
was
the-
filed in 235, my lord. Long back, this affidavit was filed. Assets and liabilities affidavit is filed, already filed, my lord, in the year 12th of June 2024.
So what is the income shown? What is your occupation?
I'm a teacher, my lord.
Teacher?
My lord, head teacher of a middle English school, my lord. Head
Eh?
teacher of an.
Slip also I have on the last occasion, my lord. I have enclosed the salary slip also, the up-to-date salary slip. That will,
Where is that?
that case, lordship, I'll give me 1 day time because I'll make a concise note and I'll submit it tomorrow, my lord, so that it will help both the courts and the petitioner and us to, my lord, decide the issue. Only that much, my lord. Yeah.
My lord, grossly and blatantly violate these two order also itself. Supreme Court judgment they mentioned, but Annexure 1 details given how to be given. I have filed accordingly. my lord.
As per the,
He says he has done it.
yeah, I
My
have
lord,
filed,
kindly
my lord.
see, this is not done as per the, but totally violated. Man. Only it may be said, my lord, in short, it is suppression affidavit. On absolutely suppressed, except far as 10% shown. I have made such statement also in my affidavit in reply, my lord. That is the only suppression of my lord affidavit, my lord. Completely suppressed, my lord. And my lord, the Neha versus, my lord, in the case, my lord, the Supreme Court is clearly laid down the rules. If this suppresses, my lord, and I have filed, my lord, many other affidavit, two affidavits also showing.
According to you, what is your salary?
Yes, my lord. Very recently, we have filed another, my lord, affidavit showing annexing the latest salary slip, my lord. That is also, yes, my lord, that is filed IA Criminal 227, my lord, page 39.
This case is withdrawn. Withdrawn case, my lord.
Both the cases were taken together, my lord.
Yes, that's true, but
taken together. Then we filed.
his lordship is searching in 929.
In 235, my lord, we have filed. Because 235 and 929 was taken together, my lord.
So you have to file in this case now. That case is no longer here.
That has been recently withdrawn, my lord. That is why I'm making a prayer, my lord.
It is not tagged with this case now, if it is withdrawn.
Yes.
Then that record will not be here. You have to file in this case.
Earlier it was taken together, so my lord, we filed it as per my lord, understanding, my lord.
একটু আসে নাকি একটু? Maybe here, but ultimately this is case is withdrawn. We have to decide on the basis of the record of this case. How can you say, and in this order, how can we say that affidavit has been filed when this is not there on this record?
Then lordship will kindly allow us, we'll again file it, my lord. Annexing the latest salary slip, my lord.
Filed it actually when withdrawing what filed here.
My lord, by killing 5 years, my lord, keeping us on stay, and now they have withdrawn. That's not killing my time, it causes all the sufferings.
Anyway, they have paid you around 6 lakhs, have they not?
My lord, in 10 years, my lord, my lord, I already.
No, recently they have paid.
34 cases, my lord.
On
Kindly see.
regular interval, we have paid, my lord.
No, my regular interval, my lord, only court's order, my lord. My lord, 34 cases, my lord, kindly think of it, my lord, for last 10 years, my lord, running, my lord. How a housewife will run it, my lord?
No, my lord.
From my lord, she is, my lord, mentally disturbed, my lord, such a condition, my lord. Both the child,
My lord, dispute between family,
and the honorable court, my lord.
Family, petitioner's own family has been brought in this, my lord, list.
My lord, on the last occasion, my lord.
Also, these are not the, my lord, in my understanding, these are not perhaps the consideration for adjudication of this present.
Her lordship, Shamima Jahan, tried for amicable settlement last moment, my lord, but he disagreed, my lord. The wife agreed. He disagreed, my lord.
Can disagree.
That was not.
If he disagrees, we have to decide on merit.
And my lord, what happened, my lord? Even the affidavit is not, my lord, even not saying properly the state, my lord, the salary also. Then, my lord, I have annexed many documents, my lord. He has LIC policies, he has many accounts, my lord. I have filed an RTF to 8 or 6 banks, my lord. All banks said that I cannot give you because of it is a third party matter, my lord. All I have annexed, my lord. And my lord,
What salary? What is your salary now?
Salary, my lord, as per the last January 2026, my lord, page 39, the net salary, net amount is 71,860.
oh, my lord, as per the 90 plus, my
My
lord.
lord, that is the salary slip, my lord.
When?
which
It is when?
It is January 2026.
So
my lord.
thereafter it is increased, my lord, again, my lord. It is now, it is 90, from 90 to in between 90 and 95, my lord, I'm sure. And my lord, even my lord, your lordship will be strange to know that so much suppressed that he has a landed property of very costly, my lord. He has not mentioned anything of it suppressed, my lord. When the Bharatmala went there, Bharatmala Road, my lord, when they, my lord, acquired the land, he went to the court, my lord, asking for compensation, my lord. I have annexed all the title suits, my lord, or the paint of title suit. Totally suppressing, my lord. And he said that I will not give you a single penny. And we will, my lord, it is statement is there, my lord. I can show your lordship if your lordship is, my lord. So, my lord, I will compel you to commit suicide with your
My lord,
child.
These are very good.
This is recorded statement, my lord. And exactly, my lord, even my lord, both the law courts could not give could not take the money from him. Even the salary statement could not be, my lord, taken to the court, my lord. He did not submit. Only after coming to the High Court, my lord, when I have filed through my RTI application, then he came with the, my lord. Even then, my lord, after 2 orders by the court, with specific order to give the all bank statements, my lord, he has not submitted. Violating the court's
Whatever
order
I
itself.
have, my lord, I have submitted the affidavit, my lord, as per the court's direction.
And if my lord,
You filed the affidavit by
That, my lord,
next week, by Monday or Tuesday, you filed in this case.
Monday or Tuesday, but perhaps it will, because he has to come for signing, my lord. So leave is required, my lord. That is why. Some time, my lord. That latest salary slip, you know, slip, my lord.
Yes.
Okay.
Including all your affidavits.
My
If
lord,
we find that you have lodged a false affidavit and he can show that you have hidden it, then consequences will be different for you.
my lord, not only salary statement, my lord, as per Annexure A of
No, as per Neha's case.
yes,
you
per
filed.
yes, my lord, as per
As per the Rajneesh has a format, my lord, we have filed the affidavit.
He has heard learned counsel for the petitioner, learned counsel. And then submits that pursuant to orders passed by this court, he submitted the affidavit of assets and liabilities in a connected criminal revision petition. Number 235 of 21, which however has been withdrawn. Dismissed on withdrawal. Hence, filed the said affidavit. Instant case within 2 weeks you file. Again on.
the date may kindly be fixed, my lord.
29.
As per my lord, Neha, my lord, kindly mention it. Otherwise, my lord, again suppress it.
It was filed, my lord, already, but we will
In
again.
terms of the file the affidavit, in terms of the directions of the Honorable Apex Court. Neha versus Rajneesh.
39, my lord.
File before that.
Yes, my lord, definitely.
Oblige.
I think I asked the others to. Okay, we'll rise now.
Please, the lordship. Item number 53, interim order may be continued.
53.
Lord.
It is only till next date.
Yes, ma'am.
Interim order.
Until further order, my lord.
Huh?
Until further order, my lord.
Then what is the
No,
necessity?
my lord, I am praying to pass, my lord. Lordship may please to pass interim order.
No, we will not do that without seeing the file. We'll say next date of listing.
My lord.
Humble prayer would be a short date.
Yes, give a short date. Where is possible.
Oblige, ma'am. Or 53, 53, 53. Interim continue. Till next, till next.
Next date.
Okay, thank you.